For reasons mentioned in the judgment, this criminal petition is partly allowed. The FIR dated 14/8/2019, as well as the charge sheet number 2 of 2020, to the extent as it relates to the offense under Section 188 of Indian Penal Code, is set aside and quashed. However, in respect of the offense under Section 14 of the Arunachal Pradesh Public Premises Eviction of Unauthorized Occupant Act 2003 against the present petitioner, no such interference is made, and the GR case number 37/2019, which was registered on the basis of the aforesaid charge sheet, would continue in its normal course and would be taken to its logical conclusion by the trial court.
Good job, Language.
Delivery of order, item number 1.
For reasons mentioned in the order, this interlocutory application is dismissed.
Item 2.
This interlocutory application is also dismissed for the reasons stated therein.
My lord, I have some cases in Aadhaar code. Can the item number 16, 17, 20 maybe take?
16, 17, what is your prayer?
Actually, I have some matters in Aadhaar code, so can it be taken now?
No, what do you want?
My lord,
Make your submission, what do you want?
that matter may be taken up now, my lord.
Now means as first item,
Yes, ma'am.
rejected. You wait for your turn.
Yes.
May I please, the Lordship? So I have a prayer for item number 24 of today's list. May I pray that Lordship may kindly take up the matter as the first item of the hearing.
Item number?
24. This small issue, my lord, part heard matter. Only pay and recover part is that already your Lordship heard the matter. Day before yesterday also matter.
Oh,
was-
Ms. Majumdar is there.
Yes, I will inform her. Already on to the.
Okay, we'll take it up as first hearing item.
May I please, Lord? Which I am praying for an adjournment in item number 28, Lordship. Conducting counsel, Mr. A. Sattar is unwell today, Lordship. Can it be taken up on 27th, Lordship?
Item number 28.
Yes, Lord.
Have you informed the other side?
Yes,
Yeah, I have,
I'm for the appellant, Lordship.
but it
Okay.
is a very old pending case, my lord, and
You are
my-
there.
Yes, ma'am. We had a plaintiff and we owned both the cases, both the courts. Well, 27 may be taken up, but as a first item on the hearing list. Very
Item
old
number,
pending case.
item number 28. What is your name?
W. Rahman on behalf of A. Sattar.
W.
Rahman.
Rahman, Learned Counsel, submitting on behalf of Mr. A. Sattar, Learned Counsel, for the appellant, prays for an adjournment on the ground that the conducting counsel for the appellant is not well today. Learned Senior Counsel, Mr. A.C. Sharma, appearing for respondent number 2, considering the grounds stated by Learned Counsel for the appellant, does not raise any objection. However, he requests that the matter may be fixed on
27th as
27th
first
of 27th of January as first hearing item. The prayer is allowed, list accordingly.
Lordship, there is an interim order, Lordship. That
The interim order shall continue till next day.
Hello.
With your lordship's kind permission, and I'm an outstation counsel, and we have a matter for orders item number 21, but I'm for the appellant. Well, there is some grave urgency in the matter. And if Mr. Dilip Majumdar Learned senior advocate appearing for the other side, if a lordship fixes any time, my lord, we can inform him. There is some grave urgency in the matter. We are coming from Kolkata.
Have you informed him?
My lord, we will inform as and when the lordship permits us to take up the matter, my lord, we will immediately inform him.
We'll
20
take it at, at two.
Two, I think if there is no part, there is no, I thought there was an earlier matter fixed at two, I think. We have a flight at 4:30.
When do you want?
Anytime in the, in the first half, yeah, if you can be
12:45.
taken up.
At 12,
At 12.
at 12, you have to inform the
I,
others.
I said immediate inform Mr. Majumdar.
Okay.
21. Under the heading orders.
May I please your lordship, I beg to mention item number 30. The matter may.
30.
The matter may come up first week of February
Why?
with the consent of others. A date may be fixed
Heard.
on
Mm.
6
What is your name?
F.A. Ahmed.
Heard Mr. F.A. Ahmed, Learned Counsel for respondent number 1, 2, and 3, who prays for an adjournment on the ground of personal difficulty. Also heard Mr.
M. Rai on behalf of B. Sharma.
M. Rai, appearing on behalf of Learned Counsel, appearing on behalf of Mr. B. Sharma, Learned Counsel for the appellant, who does not raise any objection to the said prayer. Hence, the prayer is allowed.
A date may be fixed, my lord.
Let this matter be listed on 12th of February.
May I please, lordship, beg to mention item number 11 and 12, my lord. Lordship, matter may pass over for the day, my lord.
Which item number?
11 and 12.
Let it come, when it HCD lordship, because we have some urgency lordship in this.
Lordship, my senior is, they are like in, English council is, hospital due to some personal difficulty.
Lordship,
After
let it
Bihu, my
come-
lord.
let it come.
Okay, we will, item number 11 and 12. Let the matter be called for. We will consider your prayer at that time. Wait for your turn.
Problems, my lord.
Well, please, your lordship. Well, I beg to mention item number 3 of today's list. I'll be filing the objection today. I have supplied copies to the petitioner today. So let the matter come after, rightly after vacation.
You have informed the other side. You are there. Heard Mr. B.J. Mukherjee, Learned Counsel for the petitioner. Also heard Mr. A. Nazari, Learned Counsel for the caveator / respondent, who submits that he has filed the written objection today and prays for listing this matter after vacation. The prayer is allowed. Let this matter be listed in February first week. 6th of February.
May I please, your lordship?
Putul.
May I please, your lordship? Lordship, I beg to mention item number 4, lordship. Lordship, in this matter, we have been directed to take steps, lordship, but inadvertently, we couldn't take steps, lordship. Kindly, allow us to take steps by today's itself
You are for
for the petitioner, lord.
item, what's your name?
A. Brahma.
Heard Mr. A. Brahma, Learned Counsel for the petitioner, who submits that due to some reasons, the petitioner could not take steps for issuance of notice. Issuance of notice as directed by this court on its earlier order, and seeks some time for taking steps. The prayer is allowed. Let this matter be listed again on 5th of February.
Lordship, I'm on interim. Lord.
The interim order shall continue till next day.
Much obliged.
May it really be item 7.
May I please, your lordship. My lord, this is anticipatory bail application, my lord, and this is third occasion, my lord. Earlier, Honorable Court was pleased to reject this.
Third,
Third, my lord. But I have come with, my lord, specific new ground, my lord.
yes, what new ground?
My lord, in this case.
Where
my
is
lord-
the earlier rejection order?
My lord, on case number 161, my lord.
First is 156.
First is 156, second is 161. First was rejected due to considering the seriousness of the offense, my lord. And second was rejected for, my lord, having no new grounds, my lord. First order, my lord, page number 156,
Yes, what is your ground?
my lord. Ground on, my lord, page number 7, my lord. My lord, may I express the brief of the case in 2 seconds, my lord?
Yes,
My lord, FIR was lodged by one employee of Punjab National Bank alleging that 4 accused persons, one Kiran Das, bank manager, another Dhiraj Burman, another employee of bank, and 2 other accused petitioners who are before this honorable court, Dunu Burman and her wife Kulen Burman, has committed fraud and misappropriation of money to the amount of, my lord, to the tune of, my lord, 3 crores. That was the allegation, my lord. Now, my lord, kindly come to page number 7, my lord. May I read, my lord?
yes,
The petitioner accused that another FIR named accused person, namely Kiran Das, who was the then branch manager of Central Bank of India, Dhamdama branch, district Baska, is allowed to go on pre-arrest bail by this honorable court, order dated 1/5/2025, passed in AB number so and so and so. This was one new ground, my lord. The prime accused was given bail. Kindly, my lord, go to page number 36, my lord, the order. Is bail granting order in page number 36. And, my lord, relevant parties, my lord, page number, my lord, 40, para number 18, my lord. May I read, my lord?
yes,
However, considering the submissions made by the learned senior counsel for the petitioner as well as the documents produced before this court, that is the article of charges issued to the petitioner in connection with the disciplinary proceeding initiated against him with regard to the same allegations by the bank authority, it appears that accusation against him is regarding misappropriation of amount 25 lakhs only, which is much lesser than the earlier projected amount of rupees 3 crore 25 lakhs and 29,657. My lord, earlier in the affair, my lord, the anomalies was alleged to be to the tune of rupees 3 crore and something, but after, my lord, 6-7 months, they stated that the anomalies was only regarding 25 lakhs. And, my lord, kindly see para number 20, my lord. Number 20. It also appears that though the petitioner was not under any protection till date, however, he was not arrested by the investigating officer till date, which also shows that either the police has been unable to arrest the petitioner or it had not deemed it necessary to arrest him. Honorable court was pleased to consider this ground, my lord, when there was 8 months, and now it is more than 1 year, my lord. And I am as scapegoat, my lord. I am only driver of that branch manager, my lord. And my wife, my lord, she's running a CSP center, my lord. All the both the bank employees were already released on bail, my lord.
no, whether now police has tried to arrest you
Yes, my lord.
during
I am
this.
still
eh,
stay away from police, my lord. I have 2 minors child also, my lord. I'm completely scapegoat, my lord. I was the driver of that bank.
But
I have been working in the bank as a driver, my lord, since the year 2013. And all anomalies, my lord, happened during the tenure of this prime accused Kiran Das, my lord, from 2020 to 2024. But I have been working from since 2013, my lord. And the prime accused, my lord, that bank manager was allowed to go on bail, my lord. So I may be considered, my lord, as a case based on documents, my lord. And, my lord, I have also annexed bank statement of petitioner number 2, my lord. In all those bank accounts, bank statement, my lord, there is no transaction of more than 1-2 lakhs, my lord. 3 crore is quite impossible, my lord. And already they have come down to 25 lakhs.
no, 25 lakhs is in respect of the departmental proceeding against the bank manager. That is 25 lakhs is only with regard to the departmental proceeding which was drawn against the bank manager.
My lord,
That will
whole
not
case-
help you.
My lord, the whole transaction is whole anomalies to the tune of 25 lakhs, my lord.
No, that is not finding of the investigating officer.
They,
That is-
bank
that-
said, my lord,
bank-
bank stated that,
In the departmental proceeding
my lord.
against the bank manager.
The bank manager is the prime ego. Whatever was done under his.
Yes, Mr.
Whatever was done, my lord, not
Sharma.
beyond him, my lord. The whole anomalies, if happened, my lord, all under his control, my lord. It is not that 25 lakhs, he is responsible only 25 lakhs, not responsible for the 3 crore 25 lakhs, my lord. He is responsible for the whole anomalies. He was the manager, my lord, at that relevant point of time, my lord.
Yes, more than 1 year, 3 months. You are unable to arrest the, whether their detention is required. If they themselves appear before you.
Lordship, it will be required, Lordship, because there will be a difference between custodial interrogation and interim protection interrogation, Lordship. Facts will not come out, Lordship. To that respect, there is a judgment of the Supreme Court also, Lordship.
No, whether bank manager has been examined,
Yes, he has been examined.
what he has stated.
Shifted the blame to every other co-accused.
Except him, my lord.
So all the co-accused, Lordship, what I'm going to submit, Lordship, he may not interrupt, Lordship.
I'm sorry.
honestly
I'm sorry.
saying, Lordship.
Okay.
Lordship, there are number of co-accused, Lordship. Amount is very high, still under investigation, and all the co-accused who are under interim protection, they are shifting the blame to one another. The cash deposit to self-help group, Lordship, the loan that has been sanctioned, if once SHG, Lordship, self-help group is sanctioned 3 lakhs for a loan, Lordship, they are given 6 lakhs in the account. Thereafter, 3 lakhs were given to them and 3 lakhs were taken away by these co-accused. That is the modus operandi. Without any voucher, without any check, the money was withdrawn. And all the official of the bank are under the MD. So Lordship, investigation is going on in that regard. Now, Lordship, one interesting thing Lordship will see, this is his third bail application. Lordship will kindly come to paragraph number 3. Lordship, I do not have a copy of the earlier to bail application, Lordship, but I am placing before your Lordship this paragraph number 3. Lordship will kindly see where he has stated that the petitioner number 2 is the owner of a CSP. And in the other two bail application, whether he made any statement that the petitioner number 2 was the owner of a CSP, Lordship. Now he has stated before your Lordship that she is the owner of a CSP, whether it is corroborated by the statement made in paragraph number 3. First question, Lordship.
No, where he has stated.
Paragraph
My
number
lord,
3, Lordship.
paragraph number 1, my lord.
No,
paragraph number-
I'm placing reliance on paragraph number 3.
Yes.
Paragraph number 3, Lordship will see that the petitioner beg to state that the allegation level against the petitioner through the aforesaid AJR is totally false and fabricated. The actual fact of the case is that petitioner number 1 is working as a driver in the Central Bank of India at Dhamdama branch in district Baksa, Assam since the year 13 and drives the vehicle of the branch manager. Oh, fine. The petitioner number 2 is wife of the petitioner number 1 and had been working as branch business correspondent of Central Bank of India, so and so. Where is this mentioned, Lordship, that she is the owner of a CSP or CSP, Lordship?
My lord, may I say?
And in the earlier two bail application, Lordship, whether he made that statement. From the investigation, now it has come, Lordship, that the petitioner number 2 is the owner of a CSP, where all those acts were done. Second point, Lordship. Lordship will kindly see the bank account statement that there is annexed. From page 43, it will start. Lordship has found it.
Yes.
Lordship will kindly see the date 31/12/21. It starts from the bank account statement
Yes.
in the left-hand side corner. And it is up to Lordship. In in any case, Lordship, the bank account statement that have been annexed, Lordship, from the field inquiry team, which was constituted by the bank, Lordship, an inquiry was done, and it was found, Lordship, that 3 crores was credited to the account of petitioner number 1, with effect from 1/4/21 to 18/4/22. Interestingly, Lordship, those bank account statements are not annexed here. That date, Lordship, where is that date? He is a driver, Lordship. Three crore was transacted through his account. It was withdrawn by self. And the other two earlier bail application, Lordship has already gone through every detail of that, thereby rejecting the bail application. No new ground, Lordship, his involvement is thoroughly there. Misleading facts, Lordship, before your Lordship, so I am praying for dismissal of the same.
Lordship, my lord, CS branch business head, my lord, branch business head are commonly said as CSP center, my lord, in page number 3, my lord, para number 1, I have annexed documents, my lord. Page number 3, my lord, para number 1, may I read, my lord? The petitioner before Lordship are the citizen of India. The petitioner number 1 is a driver by profession, and the petitioner number 2 had been running a customer service point CNP under Central Bank of India at Thamdama branch in the district of Baska, Assam. Copy of letter, my lord, in Annexer 1, my lord. It is page number 18, my lord. I have annexed that document. It is commonly said as, my lord, CSP center, my lord, customer service point, and technical language, my lord, branch business correspondent. Annexer 1, my lord, page number 18, my lord. And maximum amount of transaction in a CSP center, branch business point, my lord, is only 49,000, my lord.
But the total transaction within the period when 1/4/2021
Yes, my lord.
to 18/4/2022
My lord,
is
now, my lord,
allegedly
my lord,
3 crores.
my lord, kindly come to page number 7, para 8, my lord. No, my lord, page number 8, my lord, para 9, my lord. Paragraph 9, my lord, page number 8. I have stated about those bank statement, my lord. May I read, my lord? Para number 9, my lord. That the petitioner beg to state that would the petitioners have more than one bank account. Petitioner number 2 has 4 numbers of bank account bearing number so and so so and so. Out of the above 4 numbers of bank accounts of the petitioner number 2, the account so and so number is her business account to run her customer service point. The petitioner beg to state that there is no illegal or unauthorized transaction in the said bank accounts of the petitioner number 2. The petitioner beg to state that in spite of the fact that they at present cannot visit their home or office for apprehension of arrest by police, yet somehow they collected some statement details of various bank account of the petitioner number 2, which clearly shows that there is no illegal or unauthorized transaction in the said bank accounts of the petitioner number 2. However, due to curtail of the movement for the reason of apprehension of arrest by the police, petitioner number 1 failed to collect his bank statement. I may be directed, my lord, to submit my all bank accounts, my lord. I
No,
will
bank,
direct it, my
bank account, police may collect from bank directly.
I also deposit, my lord, if I am giving liberty, my
No,
lord.
why?
But I cannot, since I am.
Police can collect it from the bank directly.
Report was given by the field inquiry team after finding. There is no corroboration needed.
You have the case diary.
Yes, I have the case diary. The field.
I'll go through the
That
case
is
diary.
itself in the FIR also. Lord.
Heard.
My lord, my humble submission, my lord, kindly ground of PDT may be considered, my lord. I am a scapegoat, I am a driver, and my lord, I am a small businessman, my lord, running a branch business transaction center, my lord, commonly said as CSP center. And
Now, how much money was transacted in your?
my lord, less than in all my accounts, my all my account details, my lord, so far as I have deposited, my lord. In nowhere it is more than 2 lakhs, my lord.
No, total, at one go, it was 2 lakhs.
At one go, no, my lord, per day, per no huge transaction are there in all these bank accounts, my lord. To make it 3 crores, my lord. In 4 years, no huge transaction is there. In my account of petitioner number 2, it may be there, my lord. Petitioner number 1, my lord, Pulen Burman, and I am ready to submit before the investigating agency, my lord. Because, my lord, due to taking undue advantage of bail of this honorable court, my lord, the other 2 bank employees who are main accused, without their connivance, this offense cannot be committed, my lord. They have shifted all the blame upon me. My lord, is it possible, my lord, to withdraw the money without any voucher, without connivance of the bank manager, my lord? He has been given, well, all. The main point is, my lord, this is a money lending business, my lord. The bank manager doing these illegal things never misappropriated the public money. He only lends money, taking from one account, thereafter taking from another account and repaying the earlier account, my lord. That this fact are not came to light because he's under the privilege of pre-arrest bail and he is shifting all the blame to me, my lord. So, my lord, this case is based on documentary evidence, my lord. I am ready to submit all my bank details, my lord. So, my lord, since main accused, my lord, the bank employees, bank manager was given bail, so my lord, penalty may be
Heard
considered, my
Mr.
lord.
R. Sharma, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioners, namely 1 Shri Pulen Burman and number 2 Srimati Jumi Burman, who are apprehending their arrest in connection with BI within bracket EO PS case number 6/2024 under section 120B/420/406/409 of the Indian Penal Code. Stop. It is pertinent to mention herein that this is for the 3rd time the petitioner has approached this court seeking anticipatory bail. Stop. On earlier 2 occasions, the prayer for bail, prayer for grant of anticipatory bail was rejected by this court. Stop. The gist of accusation, court para court para number 4 from page 162, 5 from page 106, and 6 from page 162. Learned counsel for the petitioner has submitted that though earlier prayer for grant of anticipatory bail were rejected by this court. However, this time the petitioners have approached the court with some new grounds which may be considered by this court. He submits that though the allegations in the FIR have been made against 4 numbers of accused persons, including the present petitioner. However, 2 accused persons, including the prime accused, namely
Kiran Das, thank you.
Shri Kiran Das, who was the manager of the Dhamdama branch of Central Bank of India, has already been granted anticipatory bail by this court. The other co-accused, namely
My lord, Dhiraj Burman.
Dhiraj Burman, has also been granted bail, anticipatory bail by this court. He submits that the initial accusation in the FIR was regarding embezzlement to the tune of rupees more than 3 crores 25 lakhs. However, However, while granting anticipatory bail to the co-accused, namely Kiran Das, where is that observation?
My lord, in page number 38,
30?
my lord. My lord, 40, my lord. Page number 40, my lord. Para number 18.
Last line, last line. This court, on the basis of the documents produced before it by the said petitioner, observed that accusation regarding misappropriation was to the tune of rupees 25 lakhs only, which is much lesser than the earlier projected amount of rupees 3 crore 25 lakh 29,657.17. He further submits that the co-accused were also granted the benefit of anticipatory bail on the ground that till consideration of their anticipatory bail application, the police was unable to apprehend them, and therefore this court opined that either police is unable to arrest the said petitioner or had not deemed it necessary to arrest him. Learned counsel for the petitioner submits that same reasoning may be applicable in case of the present petitioners. He submits that the petitioner number 1 is the driver of the petitioner number 1 was the driver of the prime accused, that is the branch manager who has already been granted anticipatory bail, whereas petitioner number 2 is is working as branch business correspondent of Central Bank of India, Dhamdama branch. Stop. Any other ground? He further submits that both the petitioners are ready to cooperate in the investigation. Stop. Any other ground?
My lord, till now, what, according to my bank statement of petitioner number 2, no major transaction was conducted, my lord.
He further submits that in the bank account of the petitioner number 2, no major transaction of money has been there, and in no case the transaction is more than how much in one day?
One day, my lord, 50,000, 49,000, my lord.
More than 49,000 in a single day.
In
Stop.
petitioner number 2.
He submits that the petitioners are ready to submit all the documents and cooperate in all the documents before the investigating officer and are ready to cooperate in the investigation. Hence, he prays that the petitioners may be allowed to go on interim bail. On the other hand, learned additional public prosecutor has vehemently opposed the grant of anticipatory bail to the present petitioners on the ground that their first anticipatory bail application was rejected by this court after finding sufficient incriminating materials against them, and said prayer was dismissed on merit. The second anticipatory bail application was also dismissed on the ground that the petitioners failed to project any new grounds which would entitle them to get anticipatory bail after rejection of their earlier application. Stop. He further submits that the offense involved in this case is a serious offense involving huge amount of money deposited by general public in the bank. He further submits that the field inquiry team, what is that?
Yes, field inquiry team of the bank.
Field inquiry team of the bank in its report has found that an amount of more than rupees 3 crores was transacted in the account of petitioner number 1 in between 1/4/2021 to 18/4/2022, which itself indicates the complicity of petitioner number 1 in the aforesaid case. What is against petitioner number 2?
Two lordship, she is the CSP owner lordship, both the husband and wife, they approached this customers lordship, self-help group. They used to deposit, I'm sorry lordship, they used to collect signature in the bank loan papers. And for withdrawal also, they, in collusion with the other members of the bank lordship, they did all the acts lordship.
He further submits that the materials in the case diary indicates the complicity of petitioner number 2 also in the alleged offense, like that of petitioner number 1. He further submits that the petitioners have failed to show any new ground which would entitle them to grant of bail in this case. You give me the case study.
Lordship, may I just add one thing, Lordship? If Lordship kindly comes to page the anomalies, Lordship, in respect of the account is of the petition number 1 and not the 2. So 2's bank account statement has been annexed here. So in this statement, as per his statement, Lordship, 49,000 and 2 lakhs. Lordship will kindly come to page 63 for a moment. Page 59.
Yes,
59 Lordship will see the credit side,
yes,
2,28,000.
yes.
Just found it. And on the next day itself, Lordship, 93,050 rupees was withdrawn.
What it indicates.
He stated that Lordship then not more than 49,000 was withdrawn.
Okay.
My lord, that is relating to, my lord, only her business account, my lord. Rest are, my lord, her own personal account. There may be that
No, acquisition is against account of
against
petition-
all the accounts.
petitioner number
But
1.
49,000 limit is only for her business account, my lord.
And
Only for her business.
Last line, only last line. So, learned additional public prosecutor has produced the case diary of the Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. I have also gone through the case diary. Stop. I'll go through the case diary and pass the orders in chambers.
Lordship, he will kindly peruse the FIR There Lordship will find the report and the findings of the report. Lordship will, may I point it out, Lordship?
Infl-
In the FIR itself, it is there. Lordship will kindly come to page 28. The type copy, Lordship will find out.
Page number,
28 is the original copy, Lordship. And Lordship will kindly come to page 19. That is the type copy.
19.
Here Lordship will see.
Now, what is the progress in the investigation?
Progress Lordship, some Lordship, there were number of SHGs Lordship. Some fake SHG have been found. It is still investigated Lordship. The bank official have been directed to furnish the documents. It has not been yet been received Lordship. So investigation to that extent is going. In Lordship, can we go to the FIR? It talks about all.
No,
the-
whether their custodial interrogation is necessary.
Will be necessary, Lordship. Because Lordship, they are the persons at the root level who bought those customers, took their signatures and money was withdrawn by them, Lordship,
Okay,
and distributed also.
okay, give me the case diary.
Yes, I
I'll
have
go.
given it.
I'll pass orders in the queue.
I beg to draw honorable court's attention, my lord, this reliability of this affair is much lesser because, my lord, affair was
Yes,
after logging of the affair, my lord.
I'll go through the case diary.
The alleged amount become very lesser, my lord. At first, they are telling 3 crores. After 6 months, they are calling it is 25 lakhs. So reliability of the affair, my lord, under question. And my lord, I may be allowed to add one ground, my lord, since my grounds are written, my lord, if honorable court permits. It's a documentary case based on documents, my lord. That may be kindly required, my lord. That may be added, my lord. This is my humble submission, my lord.
Okay,
Kindly, my lord, consider leniently, my lord. I am very poor person and scapegoat in this case, my lord.
let me
Kindly
go
consider
through the,
leniently, my lord.
let me go through the case. diary.
Oblige, my lord. Deeply obliged.
Lordship, kindly pass it over for the timing. my lord.
Timing will be difficult. We can adjourn it.
On 29, my lord, then.
No, tomorrow it can be taken up. Lordship.
What is the matter?
Lordship, here the person, he has a number of FIRs, Lordship. He was given interim on medical ground. The direction also not complied with, Lordship. They have to, by the last order also, he was directed to appear before the IO.
He has not appeared.
He has not appeared.
Then tomorrow,
Tomorrow.
heard, what is your name?
AK Borough.
Heard Mr. A.K. Borgohai, learned counsel for the petitioner, who prays for an adjournment on the ground,
The ground, my senior is on legs in another court, my lord. He will be.
on the ground that the conducting counsel for the petitioner is on legs in some other court. Also, Mr. B. Sharma, learned additional public prosecutor. Let this matter be listed again tomorrow, that is on 9th of January.
Lordship, by the last order, there was an interim.
The
protection.
interim order shall continue till tomorrow. Lawyer. Pisod mati. What is this?
Senior, some personal difficulties. We adjourn the matter. May fix the matter after the vacation.
What is this IA for?
I have for packaging the stay order.
You have filed the IA. You
Because-
have,
Because this revision does not lie at all already. There is a decision of the full court decision. Appeal lie only. Again, order of injunction, my lord.
oh yes,
The full court already held. that under an order of injunction passed under order 39, rule 1 and 2
Yes,
is
yes,
always appealable.
yes.
They have filed revision to avoid the limitation point. Order was passed long back in 2023.
When your senior will come.
Instructions from my senior regarding.
No, what is your prayer? You are praying for adjournment. Till when?
After unification.
No. Tomorrow. Tomorrow is it?
Yes, sir.
We'll fix it tomorrow because
Because the unnecessary the case is pending. Or the evidence is already going to be closed in the trial court.
why the adjournment is prayed? What is the difficulty of your senior? He has not instructed you. What is your name?
E. Chauhan.
Heard Miss B. Chauhan, Learned Counsel, appearing for Mr. S. Chauhan, Learned Counsel for the petitioners, who who prays for an adjournment on the ground of personal difficulty of the conducting counsel. The prayer is objected to by the learned senior counsel appearing for the respondent, Mr. R.C. Saikia. However, considering the submissions made by learned counsel for the petitioner, the prayer is allowed. Will it be possible tomorrow?
It will be hard tomorrow, but
Then,
matter is very simple.
then
Very
let this matter be listed tomorrow.
Tomorrow.
That is on 9th of January.
Oblige it.
Order 41, again 9 and 10.
Other side is not present. I have to him.
Miss Chaudhary is there.
Kindly take up after some time.
Okay.
Yeah, please, Lord.
Yes.
Before starting by my learned senior friend, I have a prayer, my Lord.
Yes.
Mr. Bolvia, I have engaged him. He is
Whom?
Mr. J.M. Bolvia. I have engaged him in this case, and he is in hospital duty with brother's brain operation. my Lord. So, I'm praying for a adjournment for today. my Lord. One last chance may be given.
Today means it can be fixed tomorrow.
No, my Lord, he will not be available till Bihu, my Lord.
Yes.
The last day occasion also it has been.
One last chance may be
Let
given.
it be, because they are the caveators, Lordship. I have strong submissions, Lordship, regarding their right on the admission of the second appearance. So far stay is concerned, they have something to say, Lordship.
His
Who is the appellant?
He is the appellant.
I am the appellant. I have filed this RA. Scheme of the second, section 100, Lordship.
No, you are the appellant.
Yes, Lord.
Appeal is admitted.
No, not yet to be, it is first hearing, Lord.
Okay.
Hearing on order 20. 41, 11 hearing. Lordship.
His
For
name is
formulation of substantial question of law, and then IA is there. So
What is the stage of any execution is pending?
execution
has already done,
according
my
to
lord.
them, they have been executed, but I have
And-
not yet
and
received any instructions. I have
The
applied for
execution
success
case
for
has
this.
already been
There are some
disposed of
dispute on
with
that.
full satisfaction, my lord.
No, if execution has
Done,
done,
my lord.
then we can,
Substantial question of law, appeal if.
no, we will hear it. But because of the ground shown by him, that the council's father is,
Brother,
Submission, lordship, keep it forwarded for their reply, lordship.
there is no urgency, my lord. The execution is already done. So let the matter be fixed after being. my lord.
considering the ground, we are allowing their adjournment immediately after Bihu or first week of February.
Any day after.
It
Bihu.
will be fixed, lordship, after Bihu, lordship.
First, because after Bihu also there are like, heard Mr. S.K. Poddar. S.K. Poddar, Learned Counsel for the appellant. Also heard Mr. What is your
R.
name?
Ali.
R.
R.
Ali,
Ali.
Learned Counsel for the
Creators.
caveator / respondent, who submits that in this case, Mr. J.I.
Bolvia.
Borvia has been engaged and
His brother is in hospital.
who is who has some personal difficulty today and prays for an adjournment. He further submits that in the meanwhile, the impugned decree has already been executed. Stop. Though learned counsel for the appellant has objected to the prayer for grant of adjournment. However, considering the grounds pleaded by the learned counsel for the respondent, the prayer for adjournment is allowed. Let this matter be listed. 3rd of February.
Deeply obliged.
Also, I beg to apologize. In last occasion, this honorable court has directed me to call for procure a certified copies of the order, present status of that case order. I have certified all the documents. To know the present status of the case of what is the position in the trial court. Your Lordship. Accordingly, I procured a certified copy.
Now, what is the position?
Nothing, Your Lordship, it's going on, no evidence evidence has not taken place till date. Once succession petition has been filed by the plaintiff, and thereafter defendant again give a written statement, then adjournment, these are the consequences happened since 2021 onward.
You are the plaintiff.
Lordship. Plaintiff as a witness in this case here, sir. I was a witness of this case, Your Lordship, but due to pendency of this suit, Your Lordship, my agreement has been not been executed till yet.
No, what is your grievance?
My humble submission is that to if dispose the matter with an immediate effect or give a time limit. Or I come with a very small prayer, Your Lordship.
What is the prayer?
Your Lordship, page 12. Time frame, Your Lordship. Title sheet 33 of 2021 on marriage within a fixed time frame and pass necessary. The case has been pending from 2021. I only pray before this about the time frame within the speedy disposal of this case, Your Lordship. Without going to interference of this mate of the case, Your Lordship. Because I've been badly affected for this filed by the plaintiff and defendant in another.
What is the last order?
Last order, they had filed, plaintiff has filed for substitution petition in this case. Original land order was expired. That is a Christian error. Mina Som. Now, her daughter is filing the plaintiff of this case. And ground rules have been.
Inasom has expired.
Minasum was expired. Your Lordship.
So you have made an expired party a person as respondent in this case.
Lordship, her daughter was the of this implicated.
But in this civil revision petition, how can you make an
Presented by Your Lordship, represented by the Sansita Karmuji. Your Lordship.
but in this revision petition, you have not mentioned so.
Because since it has been there in the earlier case, that at the time of filing of this case, she was not expired.
When she expired?
Was expired. Oh, say it, Your Lordship.
Otherwise, your petition is defective. You are yourself saying that Minasom has expired.
Expired and represent, I have to correct that I represented by hard data, that is to be mentioned.
Then you file a substitution.
Right.
Heard Dr. B. N. Gogoi, learned counsel for the petitioner. He has furnished the certified copies of the orders passed in title suit number 3/2021. However, during the course of his submission, he has submitted that the respondent, respondent Mina's home has already expired, and therefore he seeks leave of this court to file an appropriate application for substituting the legal heirs of the deceased respondent. The prayer is allowed. Let this matter be listed again on 9th of February.
Item 13.
Pleases your lordship. As per the last office note, lordship, this thing, the respondent has received it. R is the flag mark is the R, lordship. It's delivered.
The trial court records are there.
No, lordship, that's not there, yet to receive.
This appeal is again your wife or husband.
I'm right,
Divorce was granted.
granted, ex parte,
Okay.
and I'm,
For hearing. For hearing it will,
yes,
for hearing after receipt of the trial court's record on, you wanted it
yes,
on 12th of February.
deeply.
Item 14.
Your lordship, service is complete. Matter may come for admission.
Yes, Lordship.
Your husband or wife?
I am husband, Lordship. So the sole
Ye-
respondent. will-
You are opposing?
Yes, Lordship, I have filed Lordship,
Okay, okay.
affidavit in opposition.
Then we'll heard Miss M. Nirola, learned counsel for the petitioner. Also heard Mr.
Editor, Lordship.
A. Dutta appearing for the sole respondent. Let this matter be listed for
First week of February.
admission hearing on 9th
9th
of
of February.
February.
Deeply obliged.
The interim order shall continue till next. Where is that order 13 rule? Petition?
My lord will, that my lord will find, that page, my lord. Page,
Which impugn order was not considered?
126, page 126. Is the miss case 270 of 25. Page 126.
And where is the order?
And my lord find the order. Order lordship will find a page 136.
270.
270.
This was not considered.
Yes, sir, must be.
What is the error in this?
My lord, now lordship, will, if your lordship may kindly look into this, my lord, the 270 petition, my lord. Miss case 270, my lord. Here, my lord, so if I have lordship, I start from my lord page, my lord will kindly look into this, trial court, my lord, the judgment, out of which this, execution petition has been, pending, my lord. Now lordship may kind to page 36, my lord. Why is it necessary? Page 36.
my lord,
Yes,
page 37, para 2, my lord.
yes,
Lordship will say, may I read, Lordship?
yes.
The case for the plaintiff is in brief is as follows. The title of the plaintiff to the extent of 17 bighas, 11 katha and 3 chataks. In the second, dag number 119. If there is a typing mistake, it will be 119, Lordship. In the judgment, not 19, man. It's, one is there, but it's not legible. Anyway, man. Of Biles Labok part 1 was declared in the title suit number 62 of 71 on so and so date, and in the suit, all the co-owners were parties. Thereafter, the plaintiff filed a petition suit before the collector in which all co-issuers were parties, and the plaintiff got allotment of his share, and then possession was delivered to him on the land allotted, and the plaintiff also given a separate patta number 147, my lord. Now, my lord, this 147 patta is originally belongs to patta number 119, my lord. Second patta number 119, my lord. In which I am also a patta there. Now, lordship will find. For the described in schedule 1 of the plaintiff, defendant number 1, Sunil Kumar Datta, was the defendant number 4 in the previous title suit number so and so, and 5 bigha, 18 kata and 5 chataks in dag number 357, my lord. I am also holding land in a dag number 357. I'll show it to you, my lord. Of the first schedule has fallen in the allotted land of the plaintiff and the possession which was given to him. After the possession was delivered to the plaintiff, the defendant disposes the plaintiff in the middle of July 1972 from the land of the second schedule and the second schedule of the plaintiff, the land in which the partition patta was of the plaintiff and the defendant number 1 has no right over the same. The defendant number 2 was the defendant number 1 in the former title suit. In area of 6 katha 2 chataks in dag number 362 of 369, 89, as described in the schedule 3, was in the possession of the defendant number 2 with a temporary house, and for this reason, the collector could not deliver the possession by the demolishing the house, and in fact, the possession was delivered in as money. As the land was included in the share of the plaintiff, he is entitled to get first possession of the land. The predecessor of the defendant number 3 to 10, Shodola Bala Rai Chaudhuri, was the defendant number 9 in the previous title suit. As the defendant number 3 to 10 have houses on an area of 2 bigha 10 katas in dag number 357 and 388 as described in schedule 4, the collector could not deliver first possession of to the plaintiff by demolishing the houses. As this land in the partition land of the plaintiff, he is entitled to first possession of the same, hence this suit. Now, my lord, will para 3. Defendant number 1, 3, and 5 have contested the suit by filing the joint written statement. No written statement on behalf of the minor defendant number 9 and 10 has been filed by their guardian at victim appointed by the court. The contesting defendant have contended inter alia in their WS that there is no cause of action for the so lordship will find, and the suit is bad for non-joint or necessary parties, and that the suit being continuation of PP case number 30/73/74. The civil court has no jurisdiction to try the suit in view of the provision of the land and revenue regulation. That the decree passed in the title suit and the allotment made in the PP case were obtained by plaintiff fraudulently, and as such, the plaintiff is not entitled to get any relief on the basis of the alleged decree and order. That the second RS Patta number 119, consisting an area of 35 bigha 7 kata 11 chota was previously included in the RS Patta number 63. The original owner of which was Minalini Bose, known as Miniman, who had made a will on 10/11/1982 for the half of his property was given to our adopted son Sudhir Kumar Bose, and the remainder half was to be given to the three persons, namely Sunil Kumar Datta, Dhirani, Rudra Elias, Aroti Chakraborty, Subodh Datta. Each of these three persons were given 1/6 share of the property, and she appointed an executor named Hodilal Biswas to administer the property after her death. And in the will, it is mentioned that there is a plot of land measuring 1 bigha for the church and for the quarter of the pastor of the church, and thereafter minimum gifted 1 bigha, 1 bigha 4 kata and 4 chotaks of land to Shodolabala Roy Chaudhuri by a registered gift deed dated
23/4, 1948, arrest Dag number 366, which is now the second arrest, the Patta number 357 of 119. So my lord, in Dag number 357, my predecessor interest, acquired the interest by virtue of the registered gift deed, my lord. And now 147, which is there a PP Patta, my lord, that is belongs to the original Dag number 119, which also comprise the Patta number 119, which also comprise the Dag number 357. In respect to which I am holding my lord 1 bigger 4 kata and 4 chota land by virtue of a registered gift deed. My predecessor interest. Then my lord said that minimum died in 1949-50, and the executor Hilal Bishop filed miscase number so and so in the court of district judge and obtained his probate and so date. And on obtaining the probate, the executor administered the property of the late minimum. That the executor gives so and so, Chotak excluding the church compound and the village park, and 1 bigger 4 kata of the land gifted to Sodolawala Rai Chaudhuri. 2. Sudhir Bose in the Pacific boundary, which is sold to Umar Singha and others, from which B.K. Roy Chaudhuri, the husband of the Sodolawala Rai Chaudhuri, purchased as described in Schedule 1 of the additional WS. 3. B.K. Roy Chaudhuri purchased 18 katas from the Arati Chakraborty and 18 katas from the Subodh Chandra Datta. Thereafter, see B.K. Roy Chaudhuri died, leaving the wife Solawala Roy Chaudhuri and others, who became the owner of 19 bigger 12 kata within the Pacific boundaries as described in the Schedule 2 of the additional WS. Out of 19 bigger 12 katas of Solawala Rai Chaudhuri and her sons and daughters sold so and so by sale deed dated so and so to the plaintiff as described in the item number 2 of the Schedule 3 of the additional WS, and 6 because by registered deed dated so and so to the defendant number 1 as described in item number 1 of Schedule so and 1 big of the land by registered gift deed dated 1/6/70 to the predecessor of the defendant number 3 to 10. After the sale and after Solawala Rai Chaudhuri remain owner of 18 katas, 18 katas as described in the Schedule 2 of the additional WS. But the plaintiff, by suppressing those facts so and so with fraudulent intention, created to sale deed dated so and so for an area of so and so of land as described in item number 1 and item number 2 of the Schedule 4 of the additional WS, showing transfer of this land to him by Sudhir Bose, where previously exhausted his interest. Thereafter, the plaintiff created another in Kabula dated 5/2/70, showing transfer of the land to him by Arati Chakraborty, and then obtained declaratory decree and the allotment order fraudulently. The executor gave 5 bigger 11 kata 4 chataks, including the church to village, and my lord, it's part of the repetition, my lord. Now, Lord will come to Arati Chak, who sold away her interest by sale date dated 26/9/61, an area of 4 bigger 13 kata 4 chataks to the defendant number 2, and an area of 18 katas to the predecessor of Sodolawala Rai Chaudhuri by a sale date dated so and so. Supplementing of plaintiff, my lord, this is repetition, part of this is come, my lord. Now, Lord, to make a please.
No, what do you want to show?
My lord, I want to show that that 1 bigha of the land which was gifted to my registered deed, that I am holding in 357, my lord. In Dag number 57, which my lord belongs to Patta number 119, and the my lord PP case number, which was registered, my lord, and accordingly the separate Patta was stated, my lord, 147, my lord, that originally belongs to 119, and therefore, my lord, we made an application for pulling up the record of this Patta case, my lord, so that entire matter can be sorted out. Entire matter can be sorted out, my lord.
In execution case?
In execution, we have no objection so far the execution, but we want that, my lord, they even accept our land, let them execute, my lord. Therefore, identify for the purpose of identification of the land, because lordship under section 47, that executing can go through the whole aspect, my lord, regarding satisfaction.
You have filed any application on the, apart from order 13 application?
Section 47, my lord, before the trial. Well, others, others, my lord. So that is our prayer, my lord. And lordship, I just place one now. Issue a lordship, my lord, just place my lord. That is the execution order which has been passed, but I obtained a certified copy. My lord will find, my lord.
This order, my lord, after dismissal of our division petition by lordships. My lord, that is of 26/11/2025. My lord has got it, that is a date. Now the lordship turn to the next page, my lord. The schedule of the land has been given, which to be executed. Page 2, schedule 1, my lord has got it.
Yes.
Now, my lord will find land measuring 17 bigham 11 kata 3 chotas, land with revenue so and so paisa, and the land covered by second RS patta number 40, which is carved out of PP case number 30 of 73/74, dag number 356, 357, 380, so and so that. So our land also belongs to 57, my lord. And this 147 dag, original dag was 1/9. In which also we are already holding the land, my lord. Therefore, we call for that, my lord, the record of the case, PP case number so and so, my lord. That is our, my lord, submission. The court can look into, my lord, this aspect, because record is not with us. Now, I will just place, my lord, just one judgment, my lord, 2019, 3 SCC, 13 SCC, page 25. Lordship may kindly. Para 13. My lord, para 13, that is also, my lord, order 13, rule 10, lordship will find. Now, para 13, my lord, this honorable FX court held, my lord, if bringing on the record a document is essential for providing the case by a party, ordinarily same should not be refused. The court's duty being to find out the truth, the procedural mechanics necessary to arrive at a just decision must be encouraged. We are not unmindful of the fact that the court in the process would not encourage any fishing inquiry. It would also not assist the party procuring document which should have been himself filed. So that is the PP case, my lord, that is done by the revenue authority.
No. Now, whether the decree in the present form can be executed or not, what would be the difficulty in executing the decree?
My lord, I said, my lord, there the record come, let the court identify the land. By a separate inspection also can be done. Right now, we both the parties agreed, and thereafter, my lord, it can be done also. Therefore, these PP cases is required, my lord. Record of this case is required. That is our main.
No, is
submission.
there any difficulty in identifying the decretal land?
My land is also in the same dag and same patta. They are
Maybe
in 357. They are also in the 357, my lord.
that dag may be a bigger dag.
That is also, my lord, the proper identification. That's boundary that's to be decided, my lord. They said 357, 358, but the boundary that is to be identified, my lord.
Boundary is given in the schedule. Which is the decretal land, schedule 1 or schedule 2?
My lord, the decretal landers, my lord, they have given the physical position of schedule 4, schedule 3 and schedule 4. Now, schedule 4 is ours, my lord. Land measuring out of 2 bighas so and so, lordship will find land of dag number 357. 2 bigha land is 357 of 388. 357 is our land also, my lord. The remaining portion of the land, which is the remaining proportion, whether that is to be identified, whether this land which has been carved in a separate patta, whether also encroach our land or not, also, my lord. That is why I call for the, my lord, this filing petition on order for calling of the PP record.
No, suit has been decreed in respect of a specific portion of land,
Yes, ma'am.
which has been described in the schedule.
Yes.
Now at
Now,
the
we are objecting that, my lord, this our land is also included there, my lord. Our lands are declared included there. So therefore, my lord, the identification of the land is required, my lord. After identification, let them execute, let them take their land. I have no objection, my lord. Simple as that, my lord. Simple as that, lord. My
Yes.
lord, may I submit your
Yes,
if my reference complete.
you have completed your submission.
Then I will reply, my lord, if it is required, my lord. My lord, here's what happened, my lord.
we have had a suit, madam, then it goes to partition. Partition, madam, if your lordship see, my learned friend is reading the child court judgment, madam. Your lordship may just see a few, one paragraph, the appellate court judgment. At page 92, madam, the middle fourth line,
Page 92.
92.
Yes.
Last 5 sentences, madam.
This is appellate court's judgment.
Appellate court judgment, madam. I have perused the case law of here, so and so, the case law of the Honorable High Court has held that Deputy Commissioner cannot demolish the houses under 110 of the Land Revenue, as the, this is a revenue appeal was filed under section 147 of so and so, and the Deputy Commissioner Kachar is district, it is admitted that both parties that the symbolic possession of the land of Schedule 3 and 4 was delivered to the appellant on 9/7/99. Symbolic possession was given, they have not disputed, my lord. I was given symbolic possession. And from the case law so and so, symbolic delivery of possession amount to actual delivery of possession, and from the decision of the High Court, the suit land for recovery of first possession plea that the took delivery of possession in exclusion to the award, and the Texas rule for symbolic possession has given the land lord is entitled to decree for recovery of possession. If the suit filed with the limitation from the date of
Which line you are reading?
my lord,
Which
eh,
line? Page 92?
page 82,
Page 82,
or sorry, 92.
92.
My lord.
Wait, which line?
No, 92 I have read, my lord. The next page, my lord, I think he has not given. I think page 12, he has not given, my lord. One page is missing here, my lord. One page is missing, my lord. Anyway, your lordship may see the judgment of High Court also, my lord. I think this, the judgment of High Court.
Where? Page
I
number?
just. My lord, at page 113, my lord. 113. Paragraph.
Yes.
Paragraph 14. We accordingly decide the question against referred against the appellant and in favor of the respondent, holding that section 54 civil contemplates the civil court decree in respect of nature of property directed therein aspect and in respect of partition to be affected by collector officer deputed by him in accordance with the decree of the court. Order 21 simply read so and so and so. And for foregoing reasons, I am considered opinion that the learned first appellate court is correct in holding that 110 of land regulation will not have any application in carrying out a partition in terms of a decree of the civil court. As such, the learned lower appellate court was justified in reversing the finding of the trial court in respect to issue number 3 and 4 and declaring the suit for recovery of first possession of the land included in Schedule 3 and 4 in favor of the petition. The decision in the case of what so and so, well, this is not. So, honorable appellate court has held, and your losses may just see that regarding symbolic possession also page 188. This no court had. Page 108, there are 15.
Yes.
There is also no dispute regarding the fact that pursuant to a decree passed in so and so, and the collector had delivered first possession of the plaintiff over the entire suit land described in the Schedule 1 to the plaintiff and several except the area of land covered by Schedule 3 and 4 in respect of which only symbolic possession was given by the collector to the plaintiff. So symbolic possession was given, but that was identified already. Such a recourse had to be allegedly taken by the collector since the said plot of land he was found to be in possession of the defendant 2 to 10 who were occupying by dwelling houses and buildings standing over the said plot of land. In conspect of the fact above, let me now answer the substantial question of law framed by this court. The scrutiny of the materials available on record goes to show that in terms of the decree passed in title number so
the learned collector had given symbolic possession of the Schedule 3 and 4 to the plaintiff on account of the bar constituted under section 101(1)(10) of the Assam Land and Revenue Regulation 1856, which prohibits the collector from demolishing any existing building under occupation of the one course here. The provision of section 110 of the Assam Land Revenue Regulation is quotation. So, my lord, this is the question, my lord. I have been given symbolic possession. Where is the question, my lord? And moreover, order, my lord, 13 rule, my lord, this 10 does not apply also, my lord. It is only for courts, my lord. If you also see order 13 rule 10, it is only from the courts, my lord, it can qualify in the report.
Yes, court to court.
It is not a court, my lord. It is the revenue authorities. It is not.
Court will call from the record from revenue.
No, my lord, you will also see the order 13 rule 10(1). That cannot be done.
No, what is their prayer? They are praying for calling of the record of PPK.
My lord, the revenue authority.
Yeah.
Revenue authority.
Court will call for the record.
Not for my lord. It's from the own record or from any court. Not other, my lord. And moreover, it is not necessary to, my lord, symbolic possession was given.
So whether the land has been identified,
Already
That
identified,
is the
not
question. That is the
symbolic
question.
possession was given to me.
they are questioning that unless
Yes,
the
That was already identified, my lord. That
No,
schedule is there, my lord, the boundary is there, everything is there, my lord.
My lord, similarly like this, my lord, I have given you this area. Then my lord, whether my area is situated that or not, that is to be identifiable, my lord. That we question. Lordship kindly see page 110 of the appellate, second court, second.
the
appellate court.
question of whether Nazir has given any report that it is
That,
difficult.
That will come with the report, my lord, PP report.
My lord, the revenue authorities identified the land.
That is.
And
and
symbolic possession has already been given.
Symbolic
Yeah,
possession
that's
has been
all.
given. Symbolic possession has been given. And it was also found that their houses are there. That is why they couldn't demolish it. That is why I had to file a suit.
Now,
And the
Lordship may
first
look-
appellate court as well as High Court has confirmed that. Yes, I am entitled to get the, they are dealing it. The learned executing court has, reason order has been passed at page 136, my lord.
Lordship may kindly page 110 of the, my lord, the honorable court judgment in the second opinion. Lordship will kindly pay, para 19, page 110, my lord. How the matter is dealt with by this honorable court in the second opinion.
Yes.
My lord will see, while dealing with the purport of the decree passed under order so-and-so, in the case of so-and-so, the honorable apex court has observed as follows: in a suit for partition or a separation of share, the prayer is not only for the declaration of plaintiff share in the suit, but also for division of the share by mates and bound. This involves three issues: whether the person making division is the share or interest in the suit property, or whether he is entitled to relief for division and separate possession, and how and what manner the property and should be divided by mates and bound. Now, Lordship will see. In a suit for partition or separation of the share, the court at the first instance decide whether the plaintiff is a share in the full property and whether is entitled to the division of the suit in the separate position. The decision of these two issues is exercise of the judicial function, and the result in the first stage decision term as a decree under order 20 rule 18 sub rule 1 and frame as preliminary decree. Under order 20 rule 18(2) of the code, the consequential division by mates and bound considered to be a ministerial and administrative act requiring the physical inspection, measurement, calculation, and consideration of the various permutation combination.
No, but this was done earlier.
Then
Yes,
my,
this is done.
then I will say page 20, para 20. From the aforesaid decision of the apex court, it is thus clear that that the exercise of undertaking the collector under section 54 of the CPC is carrying out a partition of revenue paying state in terms of a civil court decree, the ministerial administrative act, not involving further determination of right of the co-sharers in the removal property. Contentious issues, if any, my lord, contentious issues, if any, arising between the parties while executed would, however, have to be dealt with by the executing court in accordance with the provision of the CPC. Now, what is the contentious issue vis-a-vis this execution proceeding, my lord? Contentious proceeding between the parties, my lord, in respect, including any dispute, objection raised by the parties relating to enforcement, discharge, satisfaction, and identity of the property. That is the contentious issue. That is the contentious issue, my lord. This court is leave it open. That is why, my lord, we have filed execution on order 13 rule 10. Asking, praying for the court, we call for the record when the Najis report, everything will become clear. We are not objecting there, my lord. Let them take their position, my lord.
Where is the judgment order which has been reviewed?
Your order.
One
That last order.
143, my lord.
150.
43.
43.
That was, my lord, because they have filed, normally revision system is maintainable only just for one order, but here two orders have been impugned. That is why that is. The impugned order is at page 130. And the order passed by your lordship is 140. Impugned order is justified. When symbolic question is given, my lord, there is no question of other identity.
The two orders are for which two order? 269 and 270.
Yes. 269.
What 269 directed? What was the,
This is against the calling of the record of the title suit, my lord.
okay.
And this is what, my lord,
So only that was dealt with.
that much that lordship, exactly. mean.
Okay, okay. Heard. Mr. B.J. Ghosh, learned counsel for the review petitioner. Also heard Mr. G. N. Sahewala, learned senior counsel assisted by Mr. A. R. Pal. I am reserving the order. Hearing concluded, order reserved.
This is lovely.
Human item. Next item.
I'm hearing, my lord, for the appellate, my lord, and the applicant here, my lord. My lord, on the occasion, my lord, to deal with this matter also once. My lord, there's an order which was passed by my lord once. My lord, I'll just, my lord, give, my lord, in 2 minutes the background and then, my lord, immediately come to, my lord.
This interlocutory application, 3983.
Yes, my lord.
Okay, what
There
is?
is two interlocutory applications, my lord. One is under 151, that's 3983. And, my lord, under order 39 rule 2A, this is 3982. Now, what had happened, my lord? The original plaintiff, my lord, had filed a suit with regard to, my lord, disputed shares, my lord, of 861,918 shares, my lord, in, my lord, this one number 1 here. The shares were originally standing, my lord, in the name of, my lord, the father, Mr. Borua. Then, my lord, it was transferred, my lord, for administrative convenience, my lord, in the name of the father and, my lord, the daughter, who's, my lord, this one number 2. Then, my lord, he wanted to, my lord, transfer it back, my lord, to the family trust, by which, my lord, everyone would have got, my lord, benefit, my lord, under the shares. He refused. My lord, he filed a suit, my lord, in 2012. My lord, when he was alive, he filed a suit. And, my lord, in that suit, there was an order of status quo which was passed on, my lord, 13th August 2012. And that was the order which was, my lord, subsisting for a long time. Till, my lord, about, my lord, 2025. Because the suit, my lord, was stayed on the ground, my lord, whether, my lord, the executor should be
1312.
13 August 2012.
Okay.
That was, my lord, the original order, my lord, which was passed. Now, what happened, my lord, Mr. Borua, my lord, passed away. He left a will. Also, my lord, in the will, he said that the shares will have to go. He said the shares belong to me exclusively. The shares have to go to the trust. Now, that was, my lord, what was, my lord, the issue, my lord, in the suit itself.
Okay.
Then, my lord, what happened? My lord, the probate of the will, my lord, that application was made, my lord, before the Calcutta High Court, because, my lord, he also had properties, my lord, in Calcutta. The probate application is pending. All the other heirs, my lord, have given consent to the probate of the will, except, my lord, the one daughter, my lord, who is, my lord, contesting here as well. And, my lord, thereafter, my lord, that suit which was pending, my lord, before the Jorhat Civil Court, that was, my lord, stayed for a while because there was a question whether the executor will be substituted or not. Finally, my lord, the executor, my lord, got substituted. Then on 15th September, my lord, 2025, the original application, my lord, came up for hearing. The injunction application. And my learned friends there went and said, we have no issue, no difficulty if, my lord, the injunction order is passed, restraining them, my lord, for transferring the shares. Now, as on 15th September 2025, the shares were lying in, my lord, the account of Mr. Borua and, my lord, Shomila Shetty, which is a joint account. And, my lord, knows, my lord, these are all dematerialized shares, my lord, which are, my lord, have specific account numbers. Now, on 15th September 2025, my lord, our injunction application gets dismissed.
Putul, FAO due.
My lord, our injunction application gets dismissed. In spite of, my lord, there being a concession saying that they have no objection if the shares are not transferred. My lord, we came up, my lord, in appeal before my lord. And an order was passed, my lord, on 24th September 2025, which is, my lord, from where, my lord, I'll show the orders, which said, which restrained response number 2, which is, my lord, the daughter, from, my lord, dealing with the shares, transferring the shares. This was the order which was passed.
When?
My lord, 24th September, my lord will find the order. My lord, if my lord has, in the IA, my lord, if my lord has,
3216.
no, I think my lord has
16 of 25.
No, my lord has 3983. 3983, it's there, my lord, my lord, if my lord has
In 3983 also it is.
Yes, it is there, my lord. Kindly come to page 23. My lord has 3983, there, my lord, that's the application under 151. My lord will find, my lord, this is the order.
Yes.
24th September 2025, my lord will find it is hereby directed that till returnable date, the response number 2 shall not transfer. This 816, my lord, it was corrected later by my lord by putting in the right number of shares, 861,918 equity shares of BNN Limited, lying with the opposite party number 3. So, my lord, opposite party number 3, my lord, is HDFC Bank Limited, which, my lord, holds the shares. Because, my lord, it's in depository, it's in electronic form, they hold the shares. Now, as on that date, the shares were lying. This is very important. 24th September 2025, the shares were lying in an account of the deceased Mr. Borua, who is now, my lord, being represented by the executor, and, my lord, Shomila Shetty joint account. Now, what they did, now it is very clear, what they did after 24th September 2025 also, by suppressing the order of 24th September, they wrote to HDFC Bank.
Oh, R2.
R2. And got those shares transferred in her account, in spite of this order. By saying, oh, we are only asking for transmission, it is not actually transfer. But she was specifically restrained to have this, the respondent who shall not transfer 81698 equity shares lying with the opposite party number 3. This was the order, 24th September. And, my lord, now the HDFC Bank has also come up and said that 2 things, my lord, HDFC Bank has said. Sorry, they said we were not aware of the order. And in fact, they've gone to the extent in another affidavit saying that respondent number 2 has played fraud on the court and fraud on them by suppressing the order of 24th September and, my lord, having it transferred in their own account. Now, my lord, this section 151 application is, my lord, for the purpose to show, my lord, if one is in contempt or one is in violation of an order, it should really be put back first. Now, my lord was pleased to, my lord, kindly take, my lord, page 34. That is, my lord, the order of 19 November 2025. When again, my lord, we had asked, my lord, for transfer back, but my learned friend, my lord, had said that they had some difficulty, therefore, my lord, they did not do the matter on that date. Kindly see, my lord, page 34. This is 19th. Huh? 398.
Yes.
Heard Mr. Sansach, then my lord, heard Mr. Sansach, then paragraph 3. Learned counsel for the respondent number 2, which is, my lord, the daughter has prayed for a short accommodation on the ground of personal difficulty of the conducting counsel of the respondent number 2. Learned counsel for respondent 2 further submits that the learned senior counsel for the respondent 2 is on legs in a different court, therefore his prayer for adjournment may be allowed. 5. On the other hand, learned counsel for the applicant submits that in that event, the interim order granted on 24th September shall have to be extended. However, he points out regarding the typographical mistake in the said order. Learned counsel for applicant submits then the second last line of the said order, number of equity shares mentioned as 816918 instead of 861918, and the same shall be rectified. The learned counsel for applicant further submits, this is where that in spite of order dated 24th September 2025 of this honorable court, restraining the respondent number 2 from transferring the equity shares of B&A Limited Company, which are lying with the respondent number 3, the respondent number 2 has committed contempt of court by violating the direction of this court and has transferred the shares. Learned counsel for the applicant further submits that under such circumstances, respondent number 3 may be directed to retransfer the same to the estate of deceased Mr. H.P. Borua. After considering the submissions of learned counsel of both sides, prayer made by the learned senior counsel, learned counsel for respondent 2 for short accommodation is allowed. Then paragraph 10, figure of equity shares mentioned in the order dated 24th September passed by this court in the interlocutory application shall be read as 861918. And then 11, as regards the allegations of violation of the restraint order passed by this court, applicant may bring the same on record by filing appropriate application. Interim order dated 24th September shall continue till next date. So are allowed to file written objection. On the basis of this, both these applications have been now filed.
Which one?
The 3983, which is considering IA 3983. And also an application under order 39 rule 2A, IA 3982.
Okay.
Now, kindly look at the email by which they got it, page 29, will find of this application. By which we came to know.
29.
Page 29, will find this is the intimation given by them to the company. Page 29, in the middle.
Yes.
Will find the shares they say. In the middle, will find intimation of transposition of 861918 equity shares being limited by operation now to my name. And then form C is given at page 30.
What is this transposition?
They say, they were said that don't transfer the shares. At that time, it was lying in the account of Mr. Borua and them. That was the order. So they tried to circumvent the order by saying, instead of using the word transfer, they say, no, Mr. Borua has passed away, therefore you transpose the shares to me. Because my name is also there in the account, you give it to me.
Otherwise, shares were held jointly by respondent number 2 and the deceased.
Yes. And in a completely separate depository participant, and she was the second named holder. So, this is, and then, I just want, to take, I'm sorry, may I just request, to take once, IA 3982. Just will you give
398. Yes.
In the will, in the will, will find the will I've annexed here, the which starts at page 54. And my lord will find, my lord, at page 55, 54, my lord, kindly come to page 54. This is, my lord, a registered will.
Yes.
I, Hemendra Prasad Borua, then, my lord, that's his will. And then, my lord, kindly come to page 55.
Yes.
2.2. The said 861,918 number of equity shares of BNL Limited as above are held by me with my daughter, Mrs. Sharmila Vijay Shetty, who is the second holder. The entire consideration for acquisition of all such shares were paid by me, and no part of such consideration was paid by my daughter, and my daughter has no beneficial interest in such shares. I have applied before the Company Law Board for removal of her name as the second holder in respect of shares of BNL Limited, which was reportedly disposed of on the ground of lack of jurisdiction. I have also filed a title suit for declaration, which is one of this suit, in the matter of 861,918 numbers of equity shares of BNL Limited before the Honorable Civil Judge, and in a petition filed by me arising out of the said title suit seeking an ad interim injunction, Honorable Judge has directed to maintain status quo over the subject matter of the said title suit till disposal of the injunction application. That is, the order of 13th August 2012. Now, Mullah, kindly take, Mullah, just one more clause. Page 60, 5.1. I give, devise and bequeath my entire shareholding in BNL Limited as mentioned para 2.1 and 2.2 above, being acquired as the promoter during public issue of shares from managers as well as purchase from open market, exclusive out of my own funds, capital and savings for Hemen Borua, Benevolent and Family Trust, absolutely and forever. Now, my lord, I am the executor. I have to, my lord, maintain the estate. And, my lord, here, of course, my lord, there's a clause which says, my lord, that she is disinherited. Page 61, my lord, if just, my lord, for the record, my lord, can have a look, my lord. Clause 6.
Yes.
I mentioned such. My lord, sees amongst others will be a daughter shown as the second holder. Shares were held, and says then, my lord, 62 in the second paragraph, by action, younger daughter is trying to invade into my right over 861. She is manifestly acting in while illegal and unscrupulous manner. Then she has also surreptitiously and by playing a fraud got certain shares of BNL Limited transferred from mother in her name. Such conduct by my daughter has pained me immensely, and before I censor, declare that censor daughter is not entitled to. That's, my lord, what it says. Now, my lord, kindly look at the, my lord, all the other heirs. You can just make a note, my lord. I'm not troubling my lord with that. Page 90, page 97 and 106. All the other heirs, which includes, my lord, the family of a predeceased son, which includes the other daughter, have all given no objection to, my lord, the probate of the will. Which means, my lord, the shares will have to go to the trust, to the family trust. Now,
At what stage this probate case is?
My lord, probate case, my lord, there is a order by which, my lord, commissioner has been appointed for taking, my lord, evidence. And now, my lord, they did not appear initially. Then, my lord, they again appeared and asked for an application for recalling of that order. So, my lord, every step has been taken to delay that probate application. But, my lord, it is pending now, my lord, at the evidence stage. Now, my lord, what they do at page 220.
Of this interlocutory.
Yes, my lord, of this interlocutory application, I want to show, my lord, what they do and when they do this.
Yes.
My lord, now kindly see, my lord, it is BNL Limited, which is the company. Then, my lord, on the left hand side, NSDL and CDSL share movement register. My lord knows this is where, my lord, the shares are kept. Then holding on, then, my lord, kindly come to first see the two names, Sharmila Shetty, Hemendra Prasad Borua. The two names, my lord, has seen the first two names.
Yes.
And then, my lord, on the right hand side, very important, my lord, says holding on.
Yes.
7 November 2025. Matlab is Shormila's shares are 316200 and HP Borua is 861918. Then matlab she says that's matlab the record purchased 861918 and matlab Borua shares matlab becomes 0. I hope matlab I've
Yes.
matlab she's holding on matlab 711 and then matlab she's on the right hand side first two rows matlab holding on.
What is this page? Share movement register.
Yes, share movement register.
Maintained by whom?
Matlab maintained matlab by the depository participant.
Maintained by whom?
Matlab maintained matlab by the NSTL and CDSL. Matlab shares are kept matlab in depository participant account. Matlab the company matlab has to matlab download it.
Okay.
So I'm only showing matlab from 7th November 2025 and matlab will kindly matlab recall matlab that the order of not to transfer was passed on 24th September 2025
Continued on 19.
and continued on 19 November and matlab the order was passed matlab in her presence. So on 7 November this was the share position where Hemendra Prasad Borua matlab in his depository participant account matlab it was shown as 861918 and then matlab sees on the 14th November it becomes 0.
Yes.
And her shares increases from 316200 to 11,7811,138, 11 lakh. So the entire share matlab which was transferred is matlab added matlab to her account and matlab shown as purchased.
Yes.
Now matlab just another thing matlab I want to show and then matlab I'm going to make my prayer. Matlab now matlab there's another application IA 4154. This has been matlab filed matlab by HDFC Bank. Who is matlab the respondent number 2.
Yes.
And in 415, matlab kindly take cost title matlab will find
What for this I has been filed?
matlab HDFC Bank matlab very strange application. HDFC Bank files the application must be matlab at their matlab the instance to say please vacate the interim order.
Okay.
I don't know how matlab they're interested matlab in because they're only a depository participant. But in making this application, they have made matlab certain very important admissions which shows that they want to save themselves from a clear act of contempt. But sees at the beginning of the application on order 39 rule 4 read with sunset filed by respondent number 3.
Page number?
Matlab the first page matlab in the top of the first page of the application. I'm just showing in the matter of what is matlab their prayer, the cost title itself.
Yes.
Discharge vacating setting aside identity order 24th September. Then matlab kindly come to paragraph matlab 7.
Yes.
That the petitioner begs to state, paragraph 7, which is HDFC, that soon after disposal of miscellaneous case number 27 of 2012, thereby vacating status quo order dated 13th August, the appellant plaintiff challenged the order dated 15th September 2025 and FAO number 62, which is one of the present appeal. Along with the appeal, a fresh application under order 39 rule 1 and 2 code was filed. Being IA 3216 of 2025. Prior to filing of the said appeal, along with the injunction petition, wherein the petitioner is the party respondent, no copies of the appeal, nor memo of the copies were served to the petitioner herein, either in soft form or hard copy. The Honorable Court in its first hearing on 24th September 2025 was pleased to issue notice while admitting the appeal. An ad interim temporary injunction was also granted on 24th September. My lord has that. That is the order which I showed. On
Yes.
24th September 2025, an IA number such directing respondent number 3 not to transfer 861918 expedition of respondent number 2 company lying with the petitioner herein. DPID number, then this is very important. Lying with the petitioner herein, DPID number 301151 in demat account number such. Then pursuant to order dated 24th September, petitioner bank through UN Brahmachari had the knowledge of the order passed by this honorable court on 26th October 2025 when the certified copy of the order was received. So they have knowledge of this order of 24th September. Then Mullah, kindly skip over a few lines and kindly see at page 8. However, Mullah, see page 8, Mullah, 4th line. Mullah, the
Yes.
paragraph starting there. However, immediately, Mullah has that. However, immediately on receipt of the notice on 29th October by the UN Brahmachari branch of the petitioner bank, the same was intimated to the said Sandoz branch at Mumbai for further instructions. However, on 7th November 2025, respondent number 3, which is Mullah, the daughter, submitted transmission form as per NSDL format to release the shares held jointly in DPID number 301151 at the said Sandoz branch at Mumbai. Accordingly, papers were processed at the said Sandoz branch and instructions were sent to UN Brahmachari branch at Kolkata on 10 November. It is submitted that without there being any regulatory restriction as per NSDL, which is the nodal authority in such matters, shares were released, kindly see, from DPID number 301151 to DPID number 300476 held by the respondent number 3 in her personal capacity on 12th November 2025. And then next line, very important. It is submitted that such action was done based on order of the learned trial court passed on 15th September 2025. Same was processed as per request made by respondent number 3 herein.
What was the order on 15th September?
Mullah, that was the order, Mullah, dismissing Mullah, the injunction application from which we came up in appeal.
Okay, but
So-
they were aware about 24/9.
Yes. 24th September, Mullah, the daughter was aware it was passed in her presence.
No, whether the bank was
Yes,
aware.
bank, it says, Mullah, they received it on the 29th of October,
26.
26th of October. Yes, no difficulty, but you are aware of the order. Still, you have transferred on the 7th November. Kindly see.
On 29, whereas the injunction order was passed on 24th of September.
Then, just let me read this. Then, Mullah, kindly come to paragraph 8 at page 9 and kindly take, Mullah, the last four lines. In the soft, no, in the hard copy. Mullah, we'll see, Mullah, in page 9, paragraph 8. Last 4 lines. Format. Mullah, we'll see in that process.
Yes.
Mullah, we'll see, Mullah, last 4 lines in that process. By the time certified copy of order dated 24th September 2025 was received by the UN Brahmachari branch, Mullah, sees on 29th October 2025, the Sandoz branch in Mumbai had already processed the request made by respondent number 3 herein in terms of the order dated 15th September, passed by the learned trial court. It is submitted that 2 sets of requests were being handled by 2 different branches of the petitioner bank situated in 2 different cities. However, by the time order dated 24th September 2025 passed by Honorable Guwahati High Court was being forwarded through the petitioner, necessary instruction could not be received to halt the intending transfer of the securities. However, the petitioner respectfully submits there was no intention not to act in terms of the directions passed by the Honorable Court, by this Honorable Court, by ad interim temporary injunction ordered at 24th September. Same was also not deliberate, but due to miscommunication or procedural oversight. Then 9, that the petitioner begs to submit that it has the highest regard to any orders passed by this Honorable Court and accordingly it would abide by all such orders that may be passed in future, including any reversal orders, directions that may be passed pursuant to transmission of shares on 12th November 2025 already made. Again, Mulat sees DPID number 301151 to DPID number 30476 in facts and circumstances of the case. So, Mulat, this now, Mulat, stance or Mulat, the submission made with great respect, Mulat, to my learned friend, appearing, Mulat, for Mulat, the respondent number 2, to say that, oh, there was only transmission, no, we will not deal with the order. No, I'm with great respect, Mulat, that's not the issue. After 15 September 2025, an order was passed by this honorable court on 24th September saying you do not transfer. Which means you cannot transfer the shares which was in a different DPID number in the name of both of them.
What DP stand for in DPID?
Depository participant.
Depository participant.
Depository participant. Because now Mulat knows those Mulat days, physical shares, Mulat, I think we are much better. At least you could see those. Now Mulat, it is Mulat all in electronic form.
Okay.
And you Mulat have to apply Mulat by way of Mulat a slip or Mulat by way of Mulat a checkbook kind of thing, and Mulat they transfer.
Unless it is in physical form, how can it dematerialize also?
That's right. So Mulat, DP Mulat is depository participant. So I'm showing Mulat this was in a different account, like a bank account. It was a joint bank account. With Mulat Mr. Borua having passed away, the executor now stands in his place. Executor has been substituted. So he is the second holder. Joint account, DPID is a different account. And from that kind of bank account, now she has managed to transfer it to her own account, sole account.
Connivance of dearest bank.
And now the bank has realized one of the mistake. And the bank comes and says, oh, we are sorry, we did not know, there was miscommunication. Therefore, the transfer happened. We acted on 15th September and we are ready to transfer. Back, Mulat, to the other DP account. Then, Mulat, kindly. Then, Mulat, paragraph 11, of course, they say, Mulat, they put a hold. That is not Mulat. Then, kindly again, Mulat, see. Page 12, paragraph 12.
Yes.
The first 4 lines that the petitioner further begs, petitioner means Mulat HDFC Bank, begs to submit that it is duty bound to abide by any order directions that may be passed by this honorable court. However, the order was furnished. However, the order dated 24th September passed by this honorable was furnished in UN Brahmachari branch instead of Sandoz House branch at Mumbai, for which the shares got transferred to DPID number 300476 from DPID number 301151. However, the same was not intentional. So the bank is aware of the mistake and says that it will abide by the order of court and Mulat, they will reverse it. My learned friend Mulat, now with great respect, cannot have any audience also. Till Mulat, the act of contempt Mulat purged. And I can also show, Mulat, because we have also Mulat filed, because Mulat, the probate proceedings Mulat are pending there in Calcutta. I'm the executor, and the estate Mulat was the shares were part of the affidavit of assets. So we also filed Mulat an application there, where Mulat, we have annexed that order, where Mulat, they appeared and said that no, it is pending before the Guwahati High Court.
Cannot pass two injunction, it's not there.
And they said, no, therefore, Calcutta High Court said, quite naturally, there's already a substituting order of injunction. We are not passing any ad interim order. And Mulat, interestingly, today, Mulat, we were served Mulat with a copy of an affidavit just about an hour ago. In the Calcutta High Court, Mulat, an affidavit has been filed by HDFC Bank, where, and we are carrying the copy of the affidavit, where the bank has said that fraud was committed by the daughter on them and the court by not disclosing the order of 24th September 2025.
Showing the 15th September.
Because they relied on Mulat only 15th September without showing that there was a restraint Mulat passed by this honorable court. Mulat, I have Mulat copies of Mulat the HDFC Bank affidavit. Mulat, we can Mulat show that, my lord, if necessary, but my lord, I think, my lord, on the basis of, my lord, the application made, my lord, this should be, my lord, enough, my lord, with great respect and humility I submit that, my lord, today, my lord, to have it reversed, and then, my lord, whatever they want to say, my lord, in the appeal, my lord, can be, my lord, heard after that. Because, my lord, I've shown that the
The
shares,
prayer for reversal is made in which end?
my lord, prayer for
1-5.
reversal, my lord, is made in 3983. Page 20 of, my lord, 3983. Kindly, my lord, come to, my lord, page 20. My lord, will find, my lord, prayer
Yes,
to forthwith reverse the erroneous and illegal transfer of 86198 shares of the company BNL Limited from the first named holder Hemendra Prasad Borua to the second named holder Sharmila Shetty with a form attached Sana. So the share register maintained by the respondent one reflect sunset. And my lords, just give me that skipper. You have a copy of the skipper? My lord, we had, my lord, relied on, I don't know, my lord, it's in my lords, my lord, the court records in 1996, 4. Is it there? Copy may be there in the records. Well, 1996, 4 Supreme Court cases, 622, which is, my lord, the law. Is it there? You don't have copy?
what is the citation?
My lord, 1996, 4 Supreme Court cases, 622.
Yes.
Is it there? I'm so sorry, my lord. I'm just, my lord, I thought, my lord, we had.
No, you may read it.
My lord, I'll just read it. My lord, we also have a soft copy. I'm so sorry, my lord, for handing over.
Yes.
My lord, paragraph, my lord, will find 17. What have you given that? No. My lord, I'll just read the paragraph. My lord, page 635, paragraph 17.
17.
17, my lord. I just read, my lord, 17. The principle that a contemner ought not to be permitted to enjoy and keep the fruits of his contempt is well settled. Muhammad Idris versus Rustam Jahangir, Babuji, this court held clearly that undergoing the punishment for contempt does not mean that the court is not entitled to give appropriate directions for remedying and rectifying the things done in violation of its orders. Petition therein had given an undertaking to the Bombay High Court. They acted in breach of it. Then the single judge held them guilty of contempt, imposed a sentence of 1 month's imprisonment. Addition thereto, the learned single judge made appropriate direction, remedied the breach of undertaking, contended before the court, was not justified in giving the aforesaid directions. Then, Mullah, kindly come to paragraph 19.
Read slowly.
I'm so sorry, Mullah. I'm so sorry.
Yes, yes, please read.
Mullah, the principle that a contemner ought not to be permitted to enjoy or keep the fruits of his contempt is well settled. In Muhammad Idris versus Rustam Jahangir, this court held clearly that undergoing the punishment for contempt does not mean that the court is not entitled to give appropriate directions for remedying and rectifying the things done in violation of its orders. Petitioner therein had given an undertaking to the Bombay High Court. They acted in breach of it. A learned single judge held them guilty of contempt and imposed a sentence of 1 month's imprisonment. In addition thereto, learned single judge made appropriate directions to remedy the breach of undertaking. It was contended before this court that the learned judge was not justified in giving the aforesaid directions, in addition to punishing the petitioners for contempt of court. The argument was rejected, holding that the single judge was quite right in giving appropriate directions to close the breach of undertaking. Then, Lord, I'm reading paragraph 19. To same effects are the decisions of Madras and Calcutta High Court in Century Flour Mills and Sujit Pal versus Probit Kumar San. In Century Flour Mills, it was held by a full bench of the Madras High Court that where an act is done in violation of an order of stay or injunction, it is the duty of the court as a policy to set the wrong right and not allow the perpetuation of the wrongdoing. Inherent power of the court, it was held, is not only available in such a case, but it is bound to exercise it to undo the wrong in the interest of justice. That was a case where a meeting was held contrary to an order of injunction. Court refused to recognize that holding of the meeting is a legal one. It put back the parties in the same position as they stood immediately prior to the service of the interim. We are on this short point as on 24th September order was passed, not to transfer. You have after that, relying on 15th September, gone ahead and had this transfer done. Let us not go in the semantics because my learned friend comes up and says, oh, it's transmission. No, you cannot have it transferred. Transmission, transfer, whatever it is, it has moved from one DP, depository participant account of two persons, where now the executor is substituted and your name to your individual name. This is the breach. This is what has happened. I respectfully praying, kindly allow prayers on 3983 of 2025. It should come back and then the appeal can be heard after. Those are my submissions.
Yes.
I am appearing for the company, respondent number 1. I adopt the argument of my learned friend, Milord. In fact, we are sailing on the same boat, Milord. Now, I'll just point out two things, Milord. Kindly see the conduct of the bank. Now, in Calcutta High Court, in the probate proceeding, they went to the extent of saying that respondent number 3 herein has committed a fraud. In that, the order of 29th of September was not brought to the notice of the bank. And now here today, what they have done. Now, my learned friend stood up to say, so there is some typographical error, these at the end of the day, you were aware of the order. In spite of that, either it is transposition or transfer, you have effected it in violation of this Honorable Court's order dated 24/9 and which was continued on 1911. Now, my lord, I have got twofold submission, my lord, apart from what my learned friend has submitted. Number one, because of the contempt which they have committed, my lord, they are not entitled to be heard. They are not entitled unless they purge with the contempt. Now, there's a Supreme Court judgment. I'll place that, my lord. I'll not read it. That's, my lord, I'll give the judgment. 2007, 8 SCC 449. Paragraph 20. Paragraph 24 4 and 20. 1 second, my lord. 24 and 25. Please have the judgment for a moment, my lord. Para 25 at page 459. An order passed by a competent court, interim or final, has to be obeyed without any reservation. If such an order is disobeyed or not complied with, court may refuse the party violating such order to hear him on merits. We are not unmindful of the situation that refusal to hear a party to proceedings on merits is a drastic step, and such a serious penalty should not be imposed on him except in grave and extraordinary situation. But sometimes such an action is needed in larger interest of justice when a party obtaining an interim relief intentionally and deliberately flouts such order by not abiding the terms of such condition on which the relief is granted in this court. Now, my lord, there is a judgment of the, my lord, House of the Lord, that is Atkinson, which is referred to. In the leading case of Atkinson, the custody of a child was given to mother by an interim order of the court, but she was directed not to remove the child out of the jurisdiction of the court without prior permission of the court. In spite of the order, the mother removed the child to Australia without prior permission of the court. On a summons by the father, court directed mother to return the child within the jurisdiction of the court. Meanwhile, an appeal was filed by the mother against the order. A preliminary objection was raised by the father that as the appellant was in contempt, she was not entitled to be heard on merit. Upholding the contention and speaking for the majority, Justice Romer observed as follows. I am clearly of the opinion that mother was not entitled, in view of the continuing contempt of the court, to prosecute the present appeal, and that she will not be entitled to be heard in support of it until she has taken the first and essential step towards purging her contempt of returning the child within the jurisdiction of the court. So therefore, my lord, relying upon this authority, my submission is, until and unless the position which was obtaining on, my lord, 24/9/25 is restored by the respondent's bank and the respondent number 3, my lord, they are not entitled to be heard on merit. That is one. Now, my lord, on merit, just small aspect, my lord. On merit, I have a small submission to make. Now, my lord, here they are taking the plea that they have not transferred the share, but they have transmitted the shares. Transport.
They have
Sorry.
filed any written objection.
Yes, yes, yes.
In that written objection, that plea has been taken.
Yes, my lord. I'm just making that submission. Now, my lord, the issue is the Mr. H.P. Borua who died, who left behind a will. During his lifetime, my lord, this suit was filed. Now, the position is absolutely clear. Now, what is the status of respondent number 3? The status of respondent number 3 is he's a second holder. Kindly mark the word second holder. It is not a joint holder. My lord, I'll place one judgment of the Supreme Court in the context of some shares held in a company where, my lord, not exactly the same situation, but more or less perimeter situation was handled by the Honorable Apex Court. There, my lord, there was a question of nomination was there, where the position is much above a second holder. Now, Supreme Court says, my lord, as a nominee, your right is subservient to the right of a statutory testament. So by being a nominee or a second holder, you do not attain the status of a
Whether nominee and second holder are same thing.
morally, my lord. Let us assume, my lord, he has some right. But end of the day, it will all depend upon the outcome of the probate proceeding.
Yes.
So till then, my lord, the status quo has to be maintained, which was directed to be maintained. And all of a sudden, what prompted the learned judge, trial court judge, my lord, to vacate the interim order, that there is no case made out. On the contrary, my lord, this matter went up to Supreme Court. On one occasion, against the order of the High Court, they approached the Supreme Court. The Supreme Court refused to interfere. Supreme Court was also of the view that until the probate proceeding comes to its logical end, the parties should maintain status quo. Now, my lord, during this interregnum, how you change the DP account from X to Y? So it amounts to transferring the share. And the executor, my lord, who is in charge of complying with the requirements of the Companies Act, how he will do, my lord? So, my lord, these are essential. I'm just giving that citation, my lord. I'm not troubling your lordship with the judgment. 2024, 4 SCC 642. Want the copy?
Yes, done, yes.
Yeah. My lord will kindly 640. Okay. In the nominal. If your lordship should kindly come to paragraphs number 59. I'll read two paragraphs, my lord, 59 and 63. Of course, it was in the context of a nominee. The first case on the point was that of Milad Shankar Raju versus Union of India, that is 1984. Consistent interpretation is given by the court on the question of nomination, where I would respectfully submit, my lord, the position of a nominee is much above a second holder. That is upon the holder's death, nominee.
What is the distinction between a joint holder and a second holder? Is there any distinction?
Joint, I mean, would enjoy equal right, but it is only a second holder. Now, during his lifetime, my lord, he has reversed that. So therefore, the status of respondent number 3 as on date is 0. She can't succeed to the state of her father. There's a clear intendment. Now, kindly see, my lord, consistent interpretation is given by the courts on the question of nomination upon holder's death. Nominee would not get an absolute title to the subject matter of nomination, and those would apply to the Companies Act, Perimeter so-and-so, and the Depositories Act 1996 as well. An individual dealing with this estate planning on succession laws understands nomination to take effect in a particular manner and expects the implication to be no different for devolution of securities per se. Therefore, an interpretation otherwise would inevitably lead to confusion and possibly complexities in succession process, something that ought to be eschewed. Now, the earlier judgments are referred to. Please come to para 62. Vesting of securities in favor of a nominee contemplated under section 109A of the Companies Act, Perimeter section so-and-so, is for the limited purpose to ensure that there exists no confusion pertaining to legal formalities that are to be undertaken upon date of the holder, and by extension to protect the subject matter of nomination from any protected litigation until legal representatives of the deceased holder are able to take an appropriate steps. The object of introduction of nomination facility White Companies Amendment Act was only to provide an impetus to the investment climate and ease the cumbersome process of obtaining various letters of succession from different authorities upon the shareholder's death. Additionally, there is a complex layer of commercial consideration that are to be taken into account while dealing with the issue of nomination pertaining to companies, or until legal heirs are able to sufficiently establish their right to succession to the company. Therefore, offering a discharge to the entity once nominee is in picture is quite distinct from granting ownership of the securities to nominee instead of legal heirs. Now, this is important. Nomination process therefore does not override succession laws. Simply said, there is no third mode of succession that Scheme of Companies Act and Depository Act aims or intends to provide. So when a legal position is otherwise also clear. End of the day, it has to be a statutory testament. Then only you can, the respondent number 3 can claim some right. I'm just indicating, my lord, what is going to happen in this suit. Therefore, in my humble submission, my lord, they have committed an act of, my lord, it's an atrocious act. They should not have resorted to. In any case, my lord, my humble submission is, my lord, in the interest of the company, the position as was obtaining on 24/9/25, my lord, should be restored. That is my humble submission.
Lord, I'll just take one, my lord, this affidavit, my lord, kindly have a look at this. Just give a copy.
Let respondent number.
Yes, my lord, I just want to put this so that, my lord, they can respond there. Kindly, my lord, have a look.
1 second. My lord, with the lordship's kind permission, can I take leave? My
Yes,
pen would be there.
yes.
My lord, kindly look at the first page and, my lord, page 8.
Affidavit filed in the probate proceeding.
Yes, probate proceeding, my lord, by HDFC. Give the other side.
That you have otherwise read out.
Yes, no, my lord,
Mentioned.
I read, my lord, from the
You have
HDFC application.
mentioned about that.
Yes, I mentioned about that. Kindly, my lord, just have a look.
Page number?
My lord, at the first page, my lord, we'll see, my lord, this first page, my lord, the covering page. This is, my lord, enclosed here with the copy of the file on behalf of respondent number 2, HDFC Bank Limited, in connection with the above matter. And then, my lord, will kindly come to page 9. Page 9.
Yes.
H and J. Page 8. Page 8. Page 8, my lord, kindly look at paragraph H. Very important. That the Sandoz branch of HDFC Bank Limited, acting bona fide on the basis of the order dated 15 September 2025, passed by this learned civil judge, Senior Division Jorhat, and upon due verification documents submitted by the respondent number 1, respondent 1, my lord, is the daughter, 2 here, including the NSDL transmission form and death certificate, remove the freeze and process the transmission request, which culminated in the transmission of 861,918 equity shares of B&L Limited on 12th November 2025, strictly in accordance with applicable NSDL SEBI regulation internal. Then, my lord, kindly look at J. At the bottom of that page, J. That taking calculated and undue advantage of the fact that the demat account could be operated from any branch of respondent number 2, respondent 2, my lord, is HDFC Bank. Respondent number 1, with full knowledge of the subsisting ad interim restraining order dated 24th September 2025, passed by the Honorable Guwahati High Court, deliberately and malafide initiated a request for transmission of shares and intentionally approached the Sandoz branch, Mumbai, with the sole object of evading and frustrating the said judicial order, knowing that the said branch would be unaware thereof. Consequently, the transmission of shares was processed exclusively at the Sandoz branch, Mumbai.
Who made the transmission request?
My lord,
Daughter.
Daughter.
Okay.
7 November, my lord, suppressing, my lord, the order of 24th September. Kindly see, knowing that the said branch would be unaware thereof. Consequently, the transmission of shares was processed exclusively at the Sandoz branch, Mumbai, which at the relevant time had no knowledge or notice of the said restraining order, as respondent number 1, this is the daughter, willfully suppressed and concealed the same and failed to disclose or produce any copy thereof, thereby committing suppression of material facts, playing fraud upon the respondent number 2, is one of HDFC Bank, and this honorable court, and deliberately circumventing the binding effect of a subsisting judicial order. My lord, after this, with great respect, my lord, there is no question, my lord, of holding on to the shares in your own account, holding on to the shares in your own account. And my lord, it should be, my lord, transferred back, and then, my lord, we can.
HDFC, I represent HDFC Bank, my lord. I just clarify two things, my lord. First of all, my lord, this vacating application 4154, my lord, that was necessitated because they had already filed an injunction petition alleging breach of injunction, my lord. What happened, my lord, during that period, my lord? This request was made before the Sendos branch, that is correct. And we had even Brahmasari branch has got no knowledge about that thing, my lord. In any case, my lord, that was as per NSDL rules that was transferred, my lord. Now, my lord, when we came to know regarding this 24th order, restraining order, ad interim temporary injunction, my lord, we had, my lord, kept on hold. The whole shares were kept on hold, my lord.
Whole means now it has already been transferred to.
No, my lord, it is
daughter.
although it is being transferred, but it's kept in hold, my lord.
Whole means what?
Whole means he cannot do anything. That is, I have annexed the one.
Transfer it back.
Yes, please. Page 79, my lord, of my petition, my lord, 4154.
4154.
We have filed an IA, my lord.
This IA can be taken up along with the injunction application.
So, my lord, we have
Page number?
79, my lord. Annexure D. So, my lord, literally, my lord, the shares is getting freeze, my lord. So we have kept in hold on 27th of November. And that is one aspect, my lord. And secondly, my lord, may I just point out one technicality, my lord, because since they have already alleged injunction violation, my lord. Because on that day, my lord, when it happened, my lord, on 7th of November, there was any temporary injunction order operating, my lord. Because as per order 39 rule 3, my lord, they had to take steps within 24 hours. That is also says as per our Guwahati High Court Civil Code orders rules 24 sub rule 3, my lord. So they took, admittedly, my lord, they took steps on 28th of October when the order was passed on 24th of September. So in that logic, in that sense, my lord, when the shares were transferred, my lord, so there was no restraining order. Just because they have alleged violation, lord. That is why we have to make that submission, my lord. Kindly see, my lord, order 39 rule 3, my lord. And admittedly, they took steps on 28th of October. So I may cite one judgment also, my lord, of the Honorable Supreme Court, my lord. Recent judgment on this point, my lord. On this point, my lord.
Regarding order 39?
Yes, rule 3. Para 9, my lord, para 7. I'm sorry, sir. Yeah. This is 2025 live law SC 791. So may I read, my lord? Para 7.
Yes.
We are of the opinion that if the court is satisfied of non-compliance by the applicant with the provisions contained in the proviso, then on being so satisfied, the court, which was persuaded to grant an ex parte ad interim injunction, confiding in the applicant that having been shown indulgence by the court, he would comply with the requirements of the proviso. It would simply vacate the ex parte order of injunction without expressing any opinion on the merits of the case.
But till now it has not been vacated. It is for the court
Yes.
to consider that provision and to
Putting it out.
vacate it.
Yeah.
But you cannot take benefit of that provision
absolutely
at
not.
this stage.
No, absolutely not, my lord.
In the contempt petition, you can take this plea. But at this stage, because the order has not yet been vacated,
Absolutely.
it
my
is
lord.
in force.
Since they have filed a petition alleging breach of injunction, that is why we have made this submission. Because they have the first.
And you have admitted before the probate court by filing an affidavit that you were misled by the daughter.
That aspect I am not aware of, my lord, because somebody else is handling the matter there. I am not handling that matter, my lord.
No, counsel may be different, but parties.
That I have to take instructions, my lord.
The affidavit is apparent.
That I have to take
Yes,
instructions.
Mr. Majumdar.
Let me first indicate that so far as the injunction violation petition they have filed here before your lordship, my lord, as against that, my lord, we couldn't file our reply because the person is residing in the USA. And the affidavit which was prepared, which has been sent for my lord, dating and swearing, after that comes, we'll file it. So other two applications, we have filed the affidavit, reply to it this morning. Lordship will kindly
In
confirm.
this 151 petition,
Yes, we have filed our reply. 151, we have filed our reply, then my lord.
we can dispose of 151 today.
Lordship, I find my reply only we may kindly be called for. today.
Reply, I say.
At 2, I can refer to the contentions.
We'll continue after lunch.
My lord,
The
great,
reply may be called for.
great. My lord, reply in both the, my learned friend will give the sleep, my lord. Two reply.
Reply to that.
Met to your lord.
Yes, so, written objection to IC.
I see, because I'll be referring to certain documents and certain petitions annexed to that reply.
Yes, Mr. Mishra.
I'm told this matter may be good for the day. My matter was set to today,
Yes.
item 27.
What is to be done?
Which option you will ask me to wait, I'll wait, otherwise.
Because today I'll be rising at 4. Some urgency is there.
Another date, 20th of January.
20
After-
January.
Immediately after.
Who is for Mr. Saiwala? This is item number
27, madam.
when we can fix.
22nd, huh? 22nd, brother, there we.
Okay. Heard Mr. D.K. Mishra, learned, assisted by Mr. B. Prasad, learned counsel for review petitioner. Also heard Mr. G.N. Sahibala, learned senior counsel assisted by Mr. A. Sahibala. This matter could not be taken up today due to paucity of time. Hence, let this matter be listed for hearing on 20 January.
At 2 p.m. madam. If you can give me-
Okay, at 2 p.m.
Sorry, my lord. Similar prayer. Today morning I made a prayer for the item number 24.
Item number 24, when?
22nd of this month.
Item number 24. Due to paucity of matter, it could not be taken up. Let this matter be listed for hearing as part of matter at 2 p.m. on 22nd of January.
But I'm told that there is no one in the office who send lordship may kindly reply.
You have furnished a copy to other side.
Then
Give us.
yes, then we can proceed.
Oh, it is bulky.
They've annexed everything possible, my lord. All court records, my lord, they have annexed. And served on us, my lord, about an hour back, but we are not, my lord, raising any. Half an hour.
এটা
before the-
খবর দিতে হোক স্পেলিং সেকশনত রেডি হলে পঠাই দিব No, we are taking up this 151
150
petition.
only. I'm only on.
This is against 151.
150.
Junction application and one.
So just give the 151.
Lordship may only take up the.
We'll take up
reply file against 150.
Apollo, IA 3983, you can. Volume 1 and volume 2.
Yes, there are 2 points.
Fourth copy.
Into return coin. Two volumes are there.
Yes.
Yes.
May I please, your lordship?
No, in this 151 application,
Right.
the question is very limited
Very
question.
limited.
That in spite of knowing that there was a stay,
Right.
why, my query is why you applied for transposition of shares?
My lord, my quick reply is, I'll go in detail. My quick reply is, first of all, there is no injunction. There is an interpretation sought to be given to the order passed by Honorable Justice P.J. Saikia that there is an injunction. There is no injunction against the bank to transfer, to transfer. This is number one. I'll show from the orders, man. And my lord, so far as 151 petition is concerned, their whole purpose is to ensure that I am deprived of all my rights as a joint holder. My lord, interpretation sought to be given to the holding of share as a second nominee, first nominee, this, that. No, my lord. Companies Act 2013 does not recognize any first holder or second holder. It recognizes joint holder. I'll show from the provisions of the Act. This is my first submission, my lord. There is no concept of first holder and second holder, my lord. Lordship may kindly take note. If this court is sought to be influenced by saying that father was the first holder, she is the second holder, this is absolutely dehors the law. And by influencing this honorable court in this way, they are trying to show that the daughter, in the absence of her father, who is otherwise under the rules of NSDL, my lord, bylaws of the NSDL, is entitled to have transmission of those shares from her father's name to daughter, is trying to take advantage of these shares. My lord, admittedly, I am the owner of 27% of the shares of that company, and their whole purpose is to deprive me of all my rights as a joint shareholder. My lord, what has happened, they are, by filing this application one after another, they are trying to obtain an order of status quo. There is a reason for this, my lord. The reason is, while they filed the suit in Jorhat, my lord, initially there was an ad interim temporary injunction of status quo. In a suit where the prayer was apprehension, the cause of action for filing the suit was that daughter may transfer the share to the third party. Lordship will kindly note, my lord. The apprehension in the suit was that daughter, who is the surviving shareholder.
Which suit?
The suit
In
against
the
which-
instant suit.
Yes, my lord. Yes. In the instance of the suit, I'll show from the plaint, I'll refer to the relevant paragraphs of the plaint. The prayer, the cause of action for filing the suit was that in the
No,
absence,
no.
my lord.
You can argue, but before that, let us first read
My lord.
the 24-9 order.
My lord.
What restraint was there?
Exactly. Lordship will kindly permit me to show that. Page 24 of this application, my lord.
Yes.
Lordship may kindly.
The last para is,
Last para. It is hereby directed that till returnable date, respondent number 2, now your Lordship will kindly turn to page 23. Who is respondent number 2? Respondent number
you are respondent number.
Yes. I am respondent number 2. I have not transferred it to any party. Now, Lordship will kindly again read this part. Respondent number 2 shall not transfer these equity shares of BNA Limited lying with opposite party number 3. My lord, Lordship will kindly bear with me. I will show from the plaint. Suit was filed not for the purpose of.
So you are saying that it restrained respondent number 2 from transferring it to some other third party.
Yes, my lord. I'll show. This is their case.
Not lying.
They are trying to interpret this order as if from the company it is being transferred to me. No. Lordship may kindly immediately refer to the plaint, my lord. They are trying to give this interpretation to this order in this way, my lord. Court did not, my lord.
Yes.
My lord, what has happened? There was a status quo order. They were using the status quo order for depriving me of all my rights. Suit was filed to restrain me from transferring these shares to a third party. But learned trial court initially passed an ex parte order of only status quo. Now, taking the advantage of this expression status quo, my lord, they have deprived me all throughout of all my rights as a shareholder, although there was no such order,
No, even if status quo would have been there,
my lord.
you were the second holder of the
No,
shares.
there is no second holder. There is no concept of second holder, my lord. I am a joint holder. My lord, it is their version that I am the second holder. Law doesn't recognize any first holder, second holder. Law says it is a joint holder. There is a reason, my lord. This suit was filed by the person, father himself, saying that I have opened a joint account. Lord Lordship, kindly permit me to show the plaintiff, my lord. Because they are trying to project in a very different way, my lord. Lordship, may kindly turn to page 123. Page 123 of this, my reply, my lord. Lordship, may straightway turn to page 127. It was filed by father. Lordship, may kindly turn to page 127 straightway, paragraph 18. Even today, my lord, they are not interested in any injunction restraining me from transferring. They were interested in obtaining a status quo order so that they can deprive me of all my rights. Para 18 has your lordship got, my lord. The plaintiff submits, plaintiff was the father, my lord. Plaintiff submits that 8,61,918 shares deposited transferred in the demat account, where in the joint names, lordship will kindly note the words, man. Joint names of the plaintiff and defendant number 2, only for it is projecting the plaintiff only for operational convenience and no beneficial interest in these shares was ever intended to be passed. So it is their contention melody in the plaintiff, but then it is joint name because a joint account was opened by father and all these shares were transferred by father in the joint account, and therefore it is joint account and joint holder and no concept of first holder, second holder. Now, Lord, will kindly turn to page 132, my lord. Why the suit was filed? 132, my lord. Paragraph 33, my lord.
Yes.
That under the NSDL rules and bylaws, and more particularly rule 12.6.1, which I'll show just now, my lord. In case of death of one of the holders in a joint demat account, they themselves are plaintiff itself says joint demat account. In case of death of one of the holders in a joint demat account, shares can be moved to another demat account solely in the name of the surviving holder, merely on receipt of an application in form specified in Annexure O along with a copy of the death certificate duly attested by the notary public or by a gazette officer along with a copy of the death certificate of the deceased holder. Now, Lord, will kindly see para 34, my lord. The plaintiff reasonably believes that upon the death of the plaintiff, the defendant number 2 will act with the undue haste and submit necessary documents to defendant number 3 for moving the shares into the demat account in her sole name, and nothing will thereafter stop. My lord, now Lord will kindly see.
Exactly.
Nothing, no, next part is important. Nothing will thereafter stop defendant number 2 from disposing of the shares in any manner she likes. So their apprehension is that you will get a transmission of these shares in your name because NSDL rules itself provides that on the death of a joint holder, automatically, my lord, they have to transfer only on the production of a death certificate. Now, after that is done, she will dispose of the shares. So, apprehension is that she may dispose of the shares to a third party. Now, let me kindly see the next paragraph. The plaintiff, in view of the aforesaid, a plaintiff has now been advised to institute the present proceedings. However, the plaintiff is filing this suit without prejudice to the right and contention of the plaintiff to seek appropriate relief against the order dispenser. Now, para 36 is important. That the plaintiff states that plaintiff is the absolute owner in respect of so-and-so equity shares and in the defendant number and in the defendant number 1 lying in demat account of so-and-so maintained by defendant. The defendant number 2 and 3 are denying and is interested to deny such right, etc. Then, my lord, also kindly see the prayer at page 13. with this apprehension that there will be a transfer of shares to the surviving shareholder, my lord, and then she will dispose it of to a third party. In this context, the suit was filed with this cause of action and with this apprehension, with a prayer for a decree made in page 13, my lord. Lord, will you kindly turn to page 13. Page 13, my lord. Running page is 135. I'm sorry, my internal page is 13.
Yes.
Declaration that the plaintiff is the sole and absolute owner of so and so shares of the defendant number 1, which is now lying in the demat account bearing number so and so in the names of the plaintiff and defendant number 2 maintained by defendant number 3. So first prayer is that kindly declare that I am the sole proprietor. Second, my lord, decree for a mandatory injunction directing defendant number 2 to execute, sign the delivery instructions, injunction directing so and so from the submit plaintiff and for transfer of the said equity shares in the sole name of plaintiff. Perpetual injunction restraining as the defendant from transferring the shares from the existing accounts maintained by defendant number 3, save to any demat account standing in the sole name of the plaintiff. All right. Now,
Which one is that? C.
Then D, perpetual injunction restraining the defendant number 2 from using the delivery slips lying with defendant number 2 bearing number so and so. Then again, perpetual injunction restraining defendants from dealing with disposing of. So your ultimate apprehension is not that it will be transferred in my name, because I am repeating, transmission of shares from one joint holder to another joint holder is a legal procedure which is automatic. I'll show from the provisions, my lord. Because, my lord, in a case where there is no litigation, if a person dies, where will the share go? If a joint holder dies, it has to go to the surviving shareholder. Now, what is the status and what is the right and competence of this plaintiff, present plaintiff, my lord? I will come to that a little later, because he is only a beneficiary under a will which is yet to be probated. So, my lord, perpetual injunction restraining the defendants from dealing with. So, their apprehension is that daughter will dispose of, daughter will enjoy the shares and dispose of. So, the suit was filed for a decree that father is the sole owner and there should not be any transmission in her name, because she may dispose of the shares. Because the plaintiff himself has clearly mentioned that in the event of his death, the shares will be under the NSDL bylaws will be transmitted, not transferred, my lord. This is not a transfer. It is transmission. Act says, my lord. I'll come to that provision, my lord.
What is the difference between?
My lord, I'm coming to that. Straightway I'm coming to that. Lordship may kindly take section 56 of the Companies Act, my lord. If your lordship is holding this book, then it will be page 60.
Section 56.
56, ma'am.
Yes.
Transfer and transmission of securities. A company shall not register a transfer of securities of a company or the interest of a member in the company in the case of a company having no share capital other than the transfer between persons, both of whose names are entered as holders of beneficial interest in the records of the depository. They will not transfer unless it is recorded as a joint holder. Unless a proper instrument of transfer in such form as may be prescribed, duly stamped, dated, and executed by or on behalf of the transferor and the transferee, and specifying the name, address, and occupation in any of the transferee has been delivered to the company by the transferor or the transferee within a period of 60 days from the date of execution, along with the certificate relating to the securities, or if no such certificate is in existence, along with the letter of allotment of securities. provided that where the instrument of transfer has been lost or the instrument of transfer has not been delivered within the prescribed period, the company may register the transfer on such terms as to indemnity as the board may think fit. This is transfer. Now, subsection 2, my lord. Nothing in subsection 1 shall prejudice the power of the company to register on receipt of an intimation of transmission of any right to securities by operation of law from any person to whom such right has been transmitted. And here they themselves have, in clear terms, without any ambiguity, stated in the plain that, see, by operation of law, that is particularly NSDL bylaws, there will be a transmission of shares in the name of the surviving joint holder. And today, they are repeatedly submitting that he is not even a joint holder. She is a second, third. Where from are you saying all these things? You are arguing beyond, you are pleading beyond the law. My lord, will kindly refer. There is a volume B. There we have annexed the company's nomination form, my lord. That also will make it very clear. May I refer to
No,
that, madam?
in the plaint, they have referred to some rule.
Yes, NSDL rules.
Which rule?
Well, that
Which is the paragraph?
My lord, that rule, I'll show that rule also, and that rule has been amended. The amended portion also I'm showing, my lord.
No, which para you referred earlier? In plain?
Para 23, my lord. Page 14, page 53 of my reply. Lords will kindly take up this volume, my lord. My reply.
Yes.
Page 53, para 23. May I read, my lord?
Page 53.
Yes, page 53, para 23.
Yes.
23, my lord, I am reading. That with regard to the statements made in paragraph 8 of the application under reply, answering respondent number 2 begs to state that the contention made as to that the respondent number 2 in collusion with respondent number 3 had transferred the entire chunk of so and so shares from first named holder to second named holder is misconceived and misleading, as there is no transfer of shares in violation of the order passed by the Supreme Court. The chunk of so and so equity shares of respondent number 1 lying in the account of respondent 3 are being held by the answering respondent number 2 and late Hemendra Prasad Barua jointly. First name holder and second name holder do not assign or confer any different right or preference based on the terminology used, and the same is nothing but a seriatim used against the holders. Joint holders are joint owners of the shares and has equal right over the shares, and therefore, while nominee under section 72 of the Companies Act 2013, if the shares are held by more than one person jointly, then the joint holders, unless nominate together, the said nomination is not valid, and respondent number 1 company's form number so and so recognizes the same. Transmission of shares in favor of opposite party number 2 after the death of joint holder is by operation of law as per bylaws of National Securities Depository Limited 1996 as amended on June 2025, framed in exercise of power conferred on section 26 of the Depositories Act 1996, and the same being approved by Securities and Exchange Board of India, and for ready reference the same is quoted herein below. 9.10 is the transmission of securities, my lord. 9.10.1, NSDL shall effect the transmission of security balances of any client due to death, lunacy, bankruptcy, insolvency, or by any other lawful means other than transfer. Transfer is one thing, transmission is another thing. Now, if it is a case of death, I've shown the provision, my lord, there will be an automatic transmission. Then it says, in case where the deceased was one of the joint holders in the client account, the surviving client shall be the person recognized by NSDL as having any title to the security balances in the joint client account. That is sufficient, my lord. I am automatically, after the death of my father, owner of the shares. And what is the projection here, my lord? That I am the second holder and I may misuse the shares. I should use the shares, my lord. Now, plain suit was filed by father. Father has in the meantime expired. And a person has filed an application saying that there is a probate under which I am the executor. Kindly substitute me. We opposed before the trial court. And they filed an application. Their application, our application, both were rejected. Both of us came to the High Court. High Court also in the civil division petition, my lord, way back around 7-8 years back, rejected our petition so that nomination, the substitution did not take place.
What happened to the suit?
I am coming to that, my lord. Interesting. After that, my lord, since we are suffering, because we are not allowed to take, my lord, enjoy the benefits of a joint shareholder, we filed an application before the trial court for modification of the order, saying that, see, your injunction was, your prayer was to injunct me from transferring to a third party, but your prayer was never to deprive me of my rights as a joint holder. That application could not be taken up by the trial court, saying that no, the application for substitution is pending, suit is kept in abeyance, we cannot take up. As against that, we came before the Honorable Court. This Honorable Court, while hearing the matter, says that unless that original order passed by Honorable Justice Indrasa is somehow modified or something, I cannot pass any order. Even if I am of the view that, in view of Binapani's judgment, my lord, of the Honorable Supreme Court, if there is a will, my lord, and if a probate petition is pending, the person who is the beneficiary of the will can be substituted. But until and unless a probate is granted, even if a decree is passed, decree cannot be enforced. That is the law, my lord. Relying on that law, we filed an application for modification of that order by filing an application.
Or allowing the substitution.
Yes, my lord, and modification of that order passed 7-8 years back, my lord. Since that was an order passed in a CRP, we filed an application to recall that order, my lord. That order was recalled, and that order is annexed, my lord, will find at page 491 of volume B. Very interesting order, my lord. I'll just read the operative part. Substitution has been allowed, but you are not going to get the benefit of the decree even if it is passed unless you get a probate.
$490.
491, my lord. I am reading only the operative part, my lord, page 519. Lordship will kindly turn to 519.
Yes.
519. Conclusions, my lord. Accordingly, this court disposes of the present application with the following observations and directions. The common judgment and order dated 13/11/2014 passed in CRP number so and so is recalled. And this is an order of 13th of June 2025 at page 491. So that order passed in CRP refusing substitution because probate was not granted was recalled. This is the first direction. Second, my lord, at page 520, Lord, kindly see. Volume B, my lord.
Yes.
Lord has got this from volume. Yes. Second direction is at page 520. This court allows CRP number so and so filed by opposite number 3 to the extent mentioned herein after and dismisses CRP number so and so. Anyway, Next, the consequential effect of allowing CRP number so and so is that the petition filed by opposite party number 3 before the trial court being petition number so and so is allowed. The deceased plaintiff is accordingly substituted by the opposite party number 3 herein in the suit as well as in the supplementary proceedings, which include the injunction application being registered as so and so. The learned trial court is directed to accordingly make necessary corrections in the post title of suit number so and so, as well as
Who is opposite party number 3, the present petitioner?
my lord. The title suit number so and so as well as supplementary proceedings are revived, and the learned trial court is directed to proceed with the disposal of the suit and supplementary proceedings. It is, however, observed that if the suit is decreed in favor of the plaintiff, the judgment and decree would come into effect only when the opposite party 3 obtains and produces the probate of the will before the learned trial court, and till then, the decree so passed in favor of the plaintiff shall be considered as a provisional and not to be given effect. I stop at that manner. No further reading is necessary. This is the status of the present petitioner appellant before your lordship. And they want a reversal of the order. What is the purpose, my lord? Purpose is to deprive a joint holder from enjoying the benefits of a shareholding. I should not participate in the meeting. I should not get dividend. Why? On what basis? What is your right? Who are you? Kindly say, what is your right as on today? Even if a decree is passed, you are not going to get the benefit of that decree unless probate is granted. That is the status of the present appellant. And they are trying to prevent the daughter, who is the joint holder, admittedly, my lord. Law recognizes joint holding. Law says there is no concept of second holder, first holder. It is your expression outside the law, beyond the pleading. My lord, injunction is a matter of discussion. And lordship will exercise discretion only when your lordship finds that the persons who have come before lordship are bona fide. What is your right to prevent me from enjoying the benefits of a shareholding? Now, my lord, after this happened, we went before the trial court, chronology of the events, my lord, and then the injunction petition, temporary injunction petition filed by them had to be pressed by them. They were enjoying the benefit of the vague expression of status quo passed initially ex parte, because they were utilizing the status quo order not for the purpose of preventing me from transferring the shares, but for the purpose of restraining me from participating in the board meeting, from getting dividend, etc., etc.
No. How you can be restrained? Suppose, assuming that you are joint holder.
Yes.
Still you can participate.
I can. They did not allow me by using the word order of temporary injunction of status quo, my lord. That is why the application we filed for modification was there initially. And then when we found that this honorable court has opened the suit by substituting them, the temporary injunction petition was heard. Now, while the temporary injunction petition was being heard, finally, I appeared for the respondent, my learned friend appeared for the plaintiff. My lord, I conceded. This is what my learned friend has said. I conceded because I clearly mentioned before the learned trial court, my lord, that I do not have any intention of transferring these shares to a third party. Kindly injunct me. I specifically mentioned before the trial court with instruction, my lord, from my learned junior, that his client does not have any intention of transferring to a third party. So let their petition be allowed. Our specific submission was that their petition for restraining me from transferring their shares to a third party be allowed. Because I have no intention of transferring the shares. In spite of that, my lord, learned trial court recorded my submission, but ultimately rejected the application. Lord, will you kindly see that order, my lord? Page.
That is the impugn order in
Yes.
here.
Yes, ma'am. And there was an interim order. I'll come to that, my lord.
So in 151 application, your first submission is that there was no direction of, there was a direct restraint on respondent number 2 from transferring share to some other party.
Yes, absolutely. The order is very clear, my lord. Direction is against me. I should not transfer. And this has to be interpreted and read in the context of the prayer made in the initial injunction petition before the trial court.
And your second submission is that by operation of the NSDL rules,
Yes.
the shares were
Transmission took place.
transmitted to
And we,
this.
my lord, we made an application for transfer. That was in 2013. I'll refer to that immediately, my lord. Where is that? My lord, Lordship, may I kindly see page 96. Page 96 of our reply, my lord. It is on the basis of this application they have done it. We did it in 2013, 26/10/2013. Our application was rather on 29/8/2013. This is a reply by the bank. Lordship, may I kindly see page 96.
Yes.
My lord, this is a letter in response to my request by the HDFC Bank, my lord, the DP, that is depository participant. Lordship has got, my lord, page 96. This is reference to your transmission request and our earlier letter dated 29/8/2013. We acknowledge the receipt of your request for transmission of securities from DP number so-and-so and client number so-and-so, ID so-and-so to client ID so-and-so, stating that the other joint account holder, they are also using the right expression, joint account holder died on 31/7/2013. In this regard, we wish to inform you that we are unable to accede to your request in view of order dated 13/8/2012 passed in Misje case number so-and-so by Civil Judge Jorhat, Assam, whereby all the parties to the suit were directed to maintain status quo over the subject matter of the suit number so-and-so, that is the equity shares lying with OP number so-and-so bank in DP ID so-and-so. Hence, we request you to provide a certified copy of revocation order and or certified copy of the court order dismissing the suit number so-and-so. They have used their own language, my lord. The fact remains that our application for transfer was in 2013 itself.
It was not for transfer. It was for transmission.
I'm sorry, I'm extremely sorry. I'm grateful to your lordship, my lord. It is transmission. Because law says that if it is a legal, my lord, father may hold some share, and in the absence of any dispute, here we have a dispute, in the absence of any dispute, the law of succession itself will say that it has to go to in the name of the daughter. In that case, it will be a transmission. It will be a transmission. Only on the production of a death certificate, there will be a transmission. It's not a transfer. And then section 56 is very clear that in the case of a transfer, there has to be a clear-cut instrument of transfer. Otherwise, other than this, no other document will be entertained for a transfer. So there is a clear difference between the transfer and transmission of shares. And my lord, lordship may kindly have a look at the prayer made in the 151 PD. There is a reason why I am showing this, my lord. No. 150. In fact, my lord, I'm sorry, my lord. I want to show the prayer made in the other petition. Their lack of bona fide, that's why I want to show.
Which petition?
In the IA 3216, where
what is 3216?
3216 is the temporary injunction petition under order 39/1 and 2. Because the motive behind this application.
No, let us first.
I am not saying that lordship will dispose of this.
Yes.
I am showing that there is a lack of bona fide and the purpose of getting this reversal of the order in a petition under section 151.
Yes. Page number?
Page number, my lord, Lordship will straightway go to the prayer, my lord. Page 16. Because even before this Honorable Court, while filing an appeal, they could have prayed for a stay. They could not make an application for stay. They made an application under Order 39, Rule 1 and 2. Of course, read with Section 151. And then in the cause title, my lord, on the first page, Lordship will kindly see what is the prayer.
Yes.
My lord, apparently, my lord, this is an application under Order 39, Rule 1 and 2. My lord, yes, under the procedure, my lord, when we file an appeal against an order of temporary injunction passed by the trial court, before the appellate court, we also file a fresh application for under Order 39, Rule 1 and 2, which they have filed. Here, the prayer is application under Order 39, Rule 1 and 2, read with Section 151 of the CPC, restraining the opposite party number 2 from transferring in any manner equity shares of BNA Limited lying with the opposite party number 3 and from using the delivery seats, and not to transfer the shares of so-and-so to restrain the opposite party number 2 from causing any transfer of whatsoever nature in respect of so-and-so. Now, Lordship will kindly see the prayer at page 16.
Yes.
In the premises, effort says so-and-so, issue notice to the respondents to show cause as to why the order impugned, dated so-and-so, passed by the learned court below, in titles number so-and-so, be not stayed. So their first prayer is that that order should be stayed, although it's not a petition matter under Order 41, Rule 5, where they can pray for a stay in an appeal before the appellate court. Then, pending before disposal of the
That was a rejection of injunction order.
Yes, my
which
lord.
is sought to be stayed.
Exactly, my lord.
Yes.
And because there is a lack of bona fide, my lord, and appeal and to show cause as to why an order granting temporary injunction as paid for in the injunction petition, order number so-and-so, and or, again, my lord, and or an order of status quo should not be passed. What is the object behind asking for an order of status quo? Because you want to revert back to the situation of the pendency of the injunction petition and the order existing at that time of status quo, because with the help of that order, you have been depriving me of all my rights as a joint shareholder, which you could not have done. That is why there is a prayer for status quo. In an application under Order 39, Rule 1 and 2, first prayer is stay, second is injunction, because without saying that they cannot, my lord, maintain the petition, and thirdly, status quo. Only for this limited purpose, I am showing this, my lord. Otherwise, your lordship is taking up that 151. So, my lord, 151 petition, they are praying for reversal because there has been a clear breach of the order. Now, I will show, my lord, why there is no breach. My lord, before I go to that, my lord, lordship will kindly see page 3983 in this IA itself, under 151, lordship will kindly see there is an order. At page 37, man. My lord, a similar prayer as in this 151 was made before the Honorable Calcutta High Court, and no relief was granted and only notice was issued. This has not been argued before lordship, my lord, by my learned friend. There was no emphasis on this. That once a prayer, similar prayer is rejected by one high court, whether the similar prayer can be made by another before another high court. My lord,
That was against the denial of injunction by the probate court.
My lord.
Probate court. Okay,
Probate in a, as your lordship is aware, in a probate proceeding, if there is a contest, it partakes the character of a suit. If there is a prayer for injunction under order 39 rule 1 and 2, an appeal will lie. Now, page 37 is the order passed by the Calcutta High Court, my lord.
yes.
Page 37, the last line, my lord. Praying for declaration that the transposition of the alleged transfer of said equity shares are null and void. Mandatory injunction is also prayed for to retransfer the said shares in the name of the estate of the deceased testator
This
along
order was passed in which case?
in the probate proceeding, my lord.
But probate proceeding is pending before which court?
Calcutta High Court.
High Court,
Calcutta High Court.
original jurisdiction.
Origin.
Okay,
That is the reason. Here we don't have.
okay. Yes.
Page 38, my lord. Said equity shares are null and void. Mandatory injunction is also prayed for to retransfer the said shares in the name of the estate of the deceased testator along with other injunctive reliefs. Affidavit in opposition shall be filed within 3 weeks. Affidavit in reply, if any, shall be filed within 2 weeks thereafter. Mr. So-and-so, my learned friend possibly, learned senior counsel submitted that the alleged shares were transferred in the name of the respondent number 1 along with his court, although this court in terms of an earlier order dated 20th of August 2025 refused to delete the aforesaid shares from the affidavit of assets on the ground that probate court cannot decide on the title of the properties. Subject matter of the will and this rigor of law cannot be circumvented by striking out some properties from the affidavit of assets. It is further submitted by Mr. Swenso that in spite of such order, the shares had been transferred by the respondent number 2 in favor of respondent number 1, the effect of which would be to frustrate the probate proceeding. In view of this exigency of the situation, an ad interim order of injunction is prayed for. Mr. Swenso learned senior counsel appearing for.
This portion is very important, what you submitted before that.
Ad interim order of injunction is prayed for. Mr. Chatterjee, the learned senior counsel appearing for respondent number 1, submitted that a suit is pending in Jorhat court, which was noted by this court in order dated Swenso for declaration of title in respect of the said shares along with the other prayers. Apart from this, an order of injunction is in force passed by the High Court of Guwahati restraining the transfer of shares. It is because it was submitted. Therefore, according to Mr. Chatterjee, a second injunction order is not warranted. After hearing both counsel and on perusing the documents annexed, it is manifest that complicated questions of law and facts are involved in this matter, which cannot be properly decided without considering rivals' contentions. There is prevailing order of injunction passed by the Guwahati High Court. Therefore, this court is not inclined to pass any interim order at this stage. So, the Calcutta High Court, my lord, did not pass any order on their petition making a similar prayer. This is what I want to show. It is another thing that Calcutta High Court has mentioned that there is an injunction order here. That order cannot say what is the order passed by the Supreme Court. Even if some interpretation is given, your lordship will kindly see what is the order passed in this case. Now I'll show my lord one thing. Lordship will now in this background see what was the order passed and what was the prayer made, and the page 24, page 25 is the relevant portion, my lord. It is hereby directed that Lordship has got my page 25.
Yes, yes.
It is hereby directed that till returnable date, respondent number 2 shall not transfer so-and-so equity shares of BNA Limited lying with the opposite party number 3. My lord, that day I was present, my learned friend was present. Even before this court, I made a submission very clearly that kindly dispose of this temporary injunction petition or the appeal with a direction that I should not transfer the shares to a third party. I made a submission, my lord. And it is on the basis of this submission.
In the
order,
IA 233216,
My
what
lord.
is the prayer?
My lord, yes.
In temporary injunction.
My lord. Page 16, Lord of the Kindness. I read my lord just now. Page 16.
Yes.
Their first prayer is there should be a stay of the order, which was rejection of their prayer. I do not know how. And second prayer is order granting temporary injunction as paid for in the injunction petition. So no fresh prayer. And thirdly, status quo. And
No, temporary injunction as prayed for in which, before the trial court?
before the trial.
What was the prayer before the trial court?
My lord, as I said, my lord,
That you are conceding.
I am saying that I am not at this stage interested to sell these shares to a third party. Your apprehension was that moment under operation of law, transmission of these shares takes place from
Yes.
joint account to
No,
your name
what was the prayer before the
trial court, my lord.
trial court in their injunction petition?
Yes.
Where
Lord-
is their injunction petition
Lord will find at page 191
of the,
of this objection, my lord.
your
You
objection?
know, I mean, there in their I also it is there.
Yes, in their IA page
I also-
number?
Page 191.
Mm, 190?
Sorry, man, not, it's not. I'm sorry, man. I think it is. Well, yes, running page 203 is the prayer, madam.
Yes, please read the,
My lord. In the premises aforesaid, it is therefore prayed that your honor would be pleased to pass ad interim injunction restraining the opposite party number 2, her servants, workmen,
who
employees.
is opposite party number 2?
Opposite party number
Bank or the you?
me, my lord.
Okay,
So prayer is to restrain me.
okay.
Restraining opposite party number 2, her agents, workmen, employees, and agents from causing any transfer in whatsoever nature in respect of so-and-so lying with opposite party number 3 in its account number so-and-so, and further restrain the opposite party number 2 from using delivery slips lying with opposite party number 2 bearing number so-and-so, and restraining directing opposite party number 3, namely HDFC Bank Limited, to transfer so-and-so shares lying in account number so-and-so and client under to issue. So the prayer is that bank should not transfer, I should not transfer, first of all, my lord. And the apprehension is, there is a apprehension that so far as transmission is there in favor of the defendant number 2 will be automatic, and she is going to dispose of the shares to a third party. So object is to restrain me from disposing of the shares to a third party till the disposal of the suit.
Which you are not, which you are
I
not,
am not saying
you
that
are conceding.
yes, madam. At this stage, I am saying that I have no intention to transfer the shares to a third party. And it is in this context, my lord, by the last order passed by this Honorable Court in their petition on 24/9/25, directed respondent number 2 shall not transfer. Who is respondent number 2, my lord? Respondent 2 is Sharmila Shetty.
Okay.
Where is the question of any violation of order, my lord? Transfer by respondent number 2 or defendant number 2 in favor of a third party has not taken place even today. And it is being repeatedly submitted that there has been a breach. Kindly reverse the order. They should not be heard. These are absurd submissions, my lord. And lordship, they are relying on that judgment. That they are relying on the judgment to say that I should not be heard, my lord. There is another paragraph relevant, my lord, para 26. So kindly have a look at that. They have read para 24, that I should not be heard. Para 26.
No, that does not matter now. I have already heard you.
My lord, my lord. It says that I should be heard. Only in an exceptional circumstance, my lord, if there is an established and clear-cut violation of an order, then this Honorable Court may say that you have violated the order. It is clear. There is no gainsaying. So I will not hear you.
So before that, court must come to the conclusion that there
Exactly,
is
ma'am.
a
That is my submission.
clear violation.
Exactly, ma'am.
Okay.
So since you are, my lord, just one more thing before I conclude, my lord. This is in the volume B, my lord, page 524, lordship will kindly see.
Page number?
Page 522. I'm sorry, page 523, madam. Page 523 is the nomination form. And nomination is another thing. If a person is holding some share, he can nominate another person. And if there is a joint holding, both of them, section 72 of the act is very clear, both of them should jointly nominate a third person. So in this case, nomination has not taken place, but nomination form itself says something which is the document of this company itself. I am showing from there, page 524, Lordship, you kindly see. It's a part of nomination form. Serial number 5, my lord. If the shares are held jointly, subsequent to the death of any one of the holders, the shares would not be registered in favor of the nominee, but would be transferred in the name of the surviving shareholder. So this is automatic, my lord, under the NSDL rules. My lord, I have shown their amended rule which they have quoted, I have read. My lord, before that, my lord, in the plaint they have mentioned, while your lordship was saying that, where is that?
Rule 9.10.2.
2, yes, my lord. I am reading rule 9.10.2 now. It was before amendment. It says like this, my lord, it is not annexed there. In case where the deceased was one of the joint holders in the client account, the surviving client shall be the person recognized by NSDL as having any title to the security balance in that joint client account. Plaint is very clear, my lord. Father opened a joint account and then father brought all his shares in the joint account of himself and his daughter. So it's a joint holding. Where from are they saying repeatedly, my lord, that first holder, second holder, in order to relegate my status to a, my lord, foreigner, an alien? That is not.
No, then what was the necessity for transferring share from one demat account to other demat account?
It is for the father to explain. I mean, the father did it.
No, bank did it.
No, man.
No,
Father.
after the death of your father,
My lord.
in spite of the restraint order is against you.
Yes.
But bank transferred the account from joint demat account to your sole account.
This is not transfer, this is transfer.
Transfer.
And this has to take place automatically because, my lord, in the absence of the father, who will be the owner, my lord? Joint surviving holder will be the
owner.
Yes.
In light of the rules
And the
9.10.2.
Yes.
So what was the necessity of transfer?
Transmission has to be done, my lord. Transmission under the NSDL rules has to take place, because unless the transmission takes place, I as a joint holder cannot exercise my right as a shareholder in the company. I cannot participate in the meetings of the board, which they want to deprive me. And admittedly, my lord, I am the holder of 27% of the shares of that company. And they are trying to keep me away so that they can take the decision without my participation. That is the whole purpose. Now, there is one other aspect. The mala fide of the appellant before lordship will be apparent from another thing, my lord. To a third person, a legal notice was sent to me, which your lordship will find at page 525, my lord. I have annexed all these documents.
Okay. And 9.10.1 says that the NSDL shall effect the transmission
Exactly,
on death.
Yes. My lord, may I just say, my lord, DP, depository participant, cannot say that my lord, depository participant's role is like this, my lord. A depository participant acts as a link between the investor and the NSDL. Investors cannot directly approach NSDL, so all transactions are done through the DP. NSDL is the main authority, my lord, and DP is the link between the NSDL and the shareholder. So a person in the middle cannot say that I will not abide by the NSDL rules.
Which branch effected the transfer? Some other branch. It is in Maharashtra, Mumbai. why it was initiated, transmission process was initiated on your application.
No, well, I filed the application 2013. That application was
On the
processed.
basis of that application,
Well, that, how it has been done, my bank will be, I mean, I have not.
no, there was some submission that since the injunction has been refused,
Yes,
the gate opened
yes,
and they transmitted.
yes.
That
yes,
is what I have. understood.
Absolutely, Malad, that's on record. It's on the basis of 7 November
my lord, my-
25th,
even
2025.
my lord,
Please,
assuming-
Factually, let us be correct.
You have not filed any other application for transmission after 2013.
Let them say.
My lord, we have only produced a copy of the order passed by the trial court. This is my instruction.
No, Malad, I'm sorry. That's factually incorrect.
Ah,
Please
Oh,
take
okay,
instructions.
we are completing, finishing.
Wait, very.
I do not know, my lord, if any application filed. I'll just find out. This part I'm not very aware. My lord, my first submission will be transmission of the shares from
Your earlier prayer in 2013 was
for transmission
for transmission, but it was not
exceeded
because of the status quo order. And as soon as the status quo order was lifted,
Yes. Transmission.
my query is whether after refusal of the temporary injunction order, have you again filed any application for transmission of?
I'll just
Okay. Yes. Yes.
My lord, just one.
Though
more
your
thing.
submission is that the injunction
not-
granted on 24/9 was only against you.
Yes. It is very clear, my lord, and it is, there are two things, my lord. Order is very clear that it is against me, and this order was passed on my submission that I have no intention, they have got an apprehension that I can transfer it, I can transfer it, I may transfer it. So I made a specific submission on instruction that my client does not have any intention to transfer the shares to a third party at this stage. So your lordship can pass that order. That is what I submitted. Based on that, this Honorable Court passed the order.
Today also you are making
Yes,
that.
I am making it. I have no intention to transfer the shares to a third party.
Okay.
It's very clear. I am very clear on that, madam. Our instructions are very clear.
Okay. What else is your submission?
My lord, injunction order, the refusal order passed by the trial court was communicated by us.
Transmission form.
And transmission form C,
Email.
one email was sent
For transmission.
for transmission. My lord, at the cost of repetition, I am submitting that there is no order passed by this Honorable Court restraining me
Okay.
for transmission. I have been restrained from transferring to a third party, which I have done. Yeah. My lord, one more aspect I wanted to show, page 525, last submission, my lord. Page 525 of this volume B of my objection. My lord. My lord, page 525 is a legal notice from a third party, my lord, saying that I have got intention to sell, my lord, because when I have made a submission before the Honorable Court and also before the trial court that I have got no intention to sell, they have now, there is a manufacturer document who has done, I don't know, but then my lord, legal notice was issued on behalf of one gentleman, Nirmal Kumar Dash, page 525, madam.
Yes. Yes.
Yes. Now, Lordship will kindly see, institution of suit and service of plaint. My client has instituted title number so-and-so before the learned civil justice senior division, so-and-so, inter alia following reliefs. Specific preference of an oral agreement, Lordship will kindly see, oral agreement dated so and so whereby defendant number 2 Sharmila Shetty agreed to sell. So this is now sought to be created, that there is an intention to sell.
This is a third party.
Third party, my lord. Now, there is a reason, my lord. And then page 527 also kindly see. Notice to the company.
No, but this would have helped the petitioner. Why are you bringing it to the
I am
notice?
bringing because after that I lodged an FIR.
Okay.
And FIR is on record, my lord. Lord will kindly see, Lord will kindly refer to the FIR. To that extent, yes, when it is to their advantage. But since it is absolutely false and baseless, and it's a manufactured thing, we lodged an FIR, which your Lord will find at page 536. And against the same person, my lord. Nirmal Kumar Das and Mr. Somnath Chatterjee, present appellant. FIR is against the appellant. Had it been a absolutely, my lord, abuse of the process, they would have filed a quashing petition by now. It's a
Only reply today.
Okay.
This is the position, my lord.
Anything?
Yes, my lord, just, my lord, my lord, my learned friend, my lord, would have taken instructions. My lord, after
Yes.
Lord, after 2013, there has been, my lord, now after the order was vacated, on 15th September, they have applied again. That's, my lord, on 7th November 2025. That is, my lord, page number 63 of IA 4154 of the bank.
Bank.
Page 63, my lord, will find.
Yes.
And this, my lord, the right to date, my lord, will find on the right hand side.
But this is a transmission form.
Yes.
And there is a difference between transmission form and transfer.
That's exactly, my lord, what they have done. My lord,
The Companies Act itself provide.
no, my lord, with great respect, my lord, my lord, I'll show, my lord, this is not a question, my lord, joint holder, it's first holder and second holder. We have the application form also, my lord, how it's done. My lord, may I just, my lord, today, my lord, the order which was passed in 2012, 13th August 2012. That's, my lord, the first order which was passed. The shares were not transferred from the DPID of the joint account. That is, my lord, what was subsisting. It was existing in another bank account. It's another, my lord, depository participant account, which was in the joint name. It was in the joint name, first holder and second holder. We have the application form as well. Doesn't matter. But, my lord, it was in another account.
Yes.
And from 2012 till, my lord, 2025, this was not transferred.
Because of the status quo order.
Yes. And now, my lord, after status quo order, 24th September, my lord, we got an order.
But that was restraint on respondent number 2.
Correct. Correct. So he could not have transferred it from the account where it existed. It is not a question of
But-
transmission.
But their submission is that transfer and transmission are two
My lord,
separate
that's what I'm
concepts.
showing, my lord, is the wrong submission with great respect to my learned friend. It existed in a certain condition. Today, my lord, he has not, my lord, 24th September, he cannot now come and say, please change the order of 24th September. That's exactly what he's asking for. He's asking for a variation of the order of 24th September. Otherwise, my lord, where is the question of my lord suppressing order of 24th September? Why did he, my lord, not apply to the bank saying that this is the order? The bank has understood correctly. Today, my lord, HDFC Bank has come and said, because my lord, they will also be in contempt. My lord knows if they are aware of an order and they act, even if they are a third party, they act, my lord, that's a CWAT principle. If they act in violation of an order, they are also in contempt.
No, you read 9.10.1.
My lord, that the NSDL rules, my lord, will only apply if there is no suit pending, if there is no dispute, no litigation. That's exactly what my learned friend submitted.
No. To understand the concept, difference between transfer and transmission.
Yes, my lord. Yes, my lord.
56 part. 56.
My lord, if this was the difference, my lord, it would have been transferred, my lord, in 2012, 2013, my lord, when my lord, Mr. Borua died, 31st July.
But their submission is that because of the status quo order, nothing could have. And now,
Status quo order, now we have again obtained an order 24th September.
and now how you would interpret the order of 24/9?
Yes, my lord, let's my lord, come back to my lord, the 24th September. It is very important. My lord, kindly come to my lord, page. Lord, I'm surprised that my lord, my learned friend, my lord, makes these submissions and repeatedly says that, oh, I will not transfer. That's not the issue. My lord, kindly come to my lord, page 24. It is hereby directed
Yes.
that till returnable date, the respondent 2 shall not transfer 816,918 equity shares of BNA Limited lying with the opposite party number 3. No, my lord, where is it lying, my lord, if I put my argument in a question form? It is lying in an account which is known as DP ID number 3011501. It is lying in that account. My learned friend cannot, my lord, twist the order and say, oh, I will transfer it to my single account.
Not a transfer, it is transmission.
Lord, transmission, transfer, my lord, let's not get involved, my lord, in this, which obviously it is to my learned friend's advantage to try and say, oh, I've it's a transmission. If it was a transmission, it would have been done, my lord, when Mr. Borua passed away. It is not. It is lying in, my lord, another account. And the order is that. And the order is, my lord, perfectly in line with, my lord, what we had asked for. You should not transfer the shares which are lying with the opposite party number 3 in a particular account. And that's what's been subsisting. From 2012, my lord, we have had this order. It has been continued on 24th September 2025 as prayed for. And now you're coming and saying, and I'll tell my lord why. Because my lord, he knows under the Articles of Association of the company, the executor becomes the first named holder. He's aware, he had challenged it in a company petition, which has been dismissed. I did not want to take my lord into that because that is not relevant for the present purpose. In the Articles of Association, and that, my lord, it's the subject matter we have stated so in the appeal as well. We have annexed the articles. My lord, is there in the Articles of Association, that's why he's aware. My lord, clause 43, my lord, wants to, my lord.
Memo appeal.
No, suppose it remains in the joint account. The shares remains in the joint.
Yes.
My query is there any embargo on the respondent number 2 in participating in board meetings?
Yes, my lord. Board
If
meeting,
there-
she's not a director. She's not a director.
If there is no status quo order.
Well, she's not a director. She's not a director, so no board meeting. Gen meetings also she cannot. Because, my lord, under the Companies Act, only, my lord, the first named holder can vote. So first question, please, I'm so sorry. Just give me the certificate. Just give me this, that account opening form. My lord, there is a, with great respect to my learned friend, if Mullah, there's a first named holder, second named holder, it's the first named holder, Mullah, who exercises the voting rights. My learned friend should say, Mullah, whether during the lifetime of the father, she has ever exercised voting right.
After the death, I have.
After the death also, she never exercised voting right.
I have to exercise.
Other juices share.
You have.
Never exercised voting rights
You have-
in respect of this shares. From 2012, no protest has been made. 2012, no protest has been made. And Mullah, kindly Mullah, just two things, Mullah, are very important. As on Mullah, August, when Mullah, the injunction order was, the status quo order was passed, the shares remained in one account. When the order of 24th September passed by this honorable court is passed, it remained in one account. Only by suppressing the order of 24th September, they applied on 7 November and had the shares transferred to their own account. Well, this is what we are saying is in breach and violation of the order which was subsisting. That's first. Secondly, my lord, my learned friend spoke about dividend. He should have also disclosed to my lord that, my lord, on the basis of an order of, my lord, 27 June 2018, 27 June 2018, passed by the Calcutta High Court, these dividends are being deposited in the testator's account, in the estate of Mr. Borua. The dividend is being deposited. That is, my lord, stated in memo, volume 3, page 35. 395. And there's been no protest about it. No protest about it. Second, my lord, today, my lord, whether the daughter can claim or not, that is the very issue in the suit. Whether, my lord, the daughter has any right or not is the very issue in the suit.
Before the probate.
No, my lord, before the Jorhat civil court. Title suit 41, my lord, that's the issue. Because this was, my lord, originally, it comes, my lord, if my lord looks at, my lord, the suit which my learned friend relied upon, page 133 of, my lord, my affidavit. My lord, of my learned friend's affidavit. Kindly, my lord, first see, my lord, page 125. No, my lord, their affidavit in opposition, my lord, which they filed in 151, IA 3983. I think I
Page number?
My lord, page number 125, my lord, should be paragraph 9 of, my lord, the plaint which we have filed.
Yes.
My lord, sees the plaintiff, which is, my lord, Borua, at all material times maintained a demat account in ICICI Bank Limited in his sole name. In the said demat account maintained with ICICI Bank Limited, plaintiff held Sansad shares of Sansad share. On 12th November, plaintiff caused to open a demat account with different number 3. This is, my lord, how it got transferred. And no money was paid, my lord, by the different number 2. Then, my lord, kindly come to, my lord, paragraph which my learned friend shown, paragraph 36 at page 133.
Yes.
My lord, sees 36 that the plaintiff states the plaintiff is the absolute owner in respect of the said 861,918 equity shares of in the different 1 lying in demat account number bearing DPID 301151 and client ID Sansad maintained by different number 3. So the subject matter of the suit is, my lord, shares lying in the dematerialized account, which is, my lord, numbered DPID 301151. And that is, my lord, the prayer at, my lord, page 135, my lord, prayers are that. It is linked, it is identified with that particular DP account. You cannot transfer it. You cannot transfer to your sole account with a different DPID. 135, my lord, sees declaration that plaintiff is the sole and absolute owner of 8619 equity shares of different number 1, which is now lying in the demat account bearing account number DPID 301151 and client ID. And then, my lord, again, prayer B, prayer C, which my lord asked also. Perpetual injunction restraining the defendants, page 136, from transferring the shares from the existing accounts maintained by the defendant number 3.
Which para?
My lord, sorry, my lord, page 136, my lord, prayer C. A I showed, then my lord, from transferring the shares from the existing account. So what I'm saying, my lord, is the whole purpose of the suit was to maintain it in that particular account. And that is where it has stood from the filing of the suit till my lord 12th November, when he suppresses the order of 24th, which is my lord very clear. The bank has commented, sorry, we were not aware of the order of 24th September. And therefore it got transferred.
Now this court will have to interpret.
Yes,
Whether bank interpreted it correctly
Lord,
or your correct interpretation is right.
well, the bank has interpreted by saying that we were not aware of 24th September, otherwise we would not have transferred. Bank's application, that's why, my lord, is very relevant. Bank said we are quite ready, happy to retransfer it. That's, my lord, their prayer. That's their averment. Sorry, not prayer, averment.
Yes, that has been shown by the respondent
Well, Lord.
too. Okay,
My lord, my prayer is also, my lord, for reverse. My lord, the reverse, my lord, the shares, my lord, I only want, my lord, whatever was the status, which means that you cannot have it transferred from the particular account. It has to go back to that account itself. Otherwise, my lord, there was no necessity. My lord, just kindly keep this in mind. My lord, sorry, my lord, just one more document. Just give me that HDFC or that letter they have disclosed. My lord, that other affidavit which I gave, my lord, just kindly have a look at that, my lord. Of, my lord, HDFC Bank, my lord, before the Calcutta High Court. Oh, I have to answer that. Page 66, my lord, will kindly have a look.
which volume there are?
No, my lord, it is, my lord, handed up, my lord, today, my lord. The Calcutta High Court, where, my lord, where, my lord, they had said that fraud had been played by the daughter on the bank.
The affidavit pointed out by bank's counsel.
My lord, gave that copy. Lord, it has a
Yes.
task legal, my lord, where I had shown, my lord, pages 7
This is before the probate court.
before the probate.
Yes.
Before the probate court. Before the probate court, kindly see, my lord, page 66. My lord, is written on 15th October 2025 by, my lord, sees the husband of, my lord, the respondent number 2. And you see, and bank, written to the bank, my lord, in Bombay, in Mumbai, there has been a huge delay in transferring my, can you see, my lord, the first, there has been a huge delay in transferring my 861918 shares of B&A Limited. Lying in my demat account, DPID number 301151. This is, my lord, the joint account at the branch in UN Brahmachari Street, which was held with my deceased father since 2008. I first sent you the order of a heavily contested matter concerning the shares held with my deceased father, dated 15 September 2025, removing any restrictions on the said shares from the Court of Civil Judge Senior Division Jorhat on the 16th of September 2025. These shares were to be transferred. I'm sorry, I do not understand what my learned friend is saying. These shares were to be transferred to my demat account, DPID number 300476, account number such at HDFC Bank Limited, Sandoz House Branch. I had provided you with the KYC documents for the account with DPID number such nearly 2 weeks ago on September 25, if any updates were required.
One day after.
I then sent you a certified copy of the same order dated 15 September 2025, removing any restrictions.
After the.
Removing any restrictions on the said shares from the Court of
Your
Civil
sub-
Judge Junior
your sub-
Division.
Your submission is that in this letter, they did not mention about 25/9,
24th September, my lord,
20
which was
24/9.
absolute. Absolute.
Okay.
Absolute. And my lord, it was transferred. That is why I said, my lord, transfer, transmission, I'm not interested. It was in the account, in a joint account.
30.
You have now caused it to be transferred or transmitted, whatever you want to say, to your own account. In violation of the order of court of 24th September. And you have, you're aware because you have deliberately suppressed it. You have suppressed it. And that's what the bank also says. Otherwise, bank would not have done it. Now it is clear. If you had shown the order of 24th September, bank would have said, sorry, I'm not doing anything.
They also understood that the same number as we.
Because their understanding, my lord, and our understanding is, my lord, the same. Now, my lord, another submission was made that, my lord, we have gone to the Calcutta High Probate Court for the purpose of, my lord, getting an order. My lord, in that order, my lord has seen what their submission was. Their submission was, there is already a subsisting order of injunction. Their submission, my lord, page 37, which my learned friend showed. You can't show me, you can't now, you are setting up one court against the other. When I go to Calcutta High Court, you say, because well, the probate is pending there, we went there. Page 37
Of
my lord, 3983. I'm surprised now, my lord, before this court, it is being said that, oh, you went to Calcutta High Court. Page 37, where, my lord, the executor had gone, quite naturally, my lord, he has to go because it's a probate, my lord, where it is pending. And it's part of the affidavit of assets.
yes.
At page 38, my lord, will find Mr. And here, my lord, respondent number 1, my lord, is Shormila Shetty. Page 38, second last paragraph. Mr. Chatterjee, learned senior counsel appearing for the respondent 1, submitted that a suit is pending in the Jorhat court, which was noted by this court, which is, my lord, the Calcutta High Court, in the order dated 20th August 2025 for declaration of title in respect of the said shares along with other prayers. Apart from this, an order of injunction is in force passed by the High Court of Guwahati restraining transfer of the shares. Therefore, according to Mr. Chatterjee, a second injunction order is not required. A second injunction order is not warranted. Then Mullah says, after hearing both counsel, there is a
That he is also not denying it.
yes,
He is also saying it.
yes. So I'm
Yes,
saying, Mullah,
His only submission is that restraint was on her
correct.
to transfer.
And Mullah, I've shown on 7 November, Mullah, he's made an application, transfer or transmission from one account to the other.
Not at all.
That's our submission.
Okay.
My lord will consider it. It's not for me to say not at all or you for with great respect. But my lord, my humble submission is it always, my lord, existed in an account which was, my lord, the status as on 24th September 2025. And my lord, my learned friend, my lord, factually is not correct submission. I'm giving a copy, my lord. This is my lord, the account opening form I've given. I did not, my lord, expect that, my lord, this submission will be made. Kindly look at, my lord, this is the original account opening form. And, my lord, kindly see the second page.
What it indicates.
My lord, kindly look at the second page. Can I just have a look?
Yes.
My lord, sees first holder. My lord, second page, first holder. And second holder, Shormila Shetty.
No, if there are joint account, there
No, it's
will
not
be.
joint. It's second holder. That's why I'm showing, my lord, this very account, the 301151. The bank will confirm this.
Second holder. I'm writing something will not change the law, man. Law doesn't.
No law, of course, it law recognizes. The voting is only by the first holder. My lord, sees, my lord, in page 2. My lord has page 2.
Yes.
This is my lord, the original account holding opening form, my lord, of this account. My lord, sees first holder Hemendra Prasad Borua, second holder Shormila Shetty. It is not my form.
Okay.
And my lord, NSDA rules, my lord, with great respect, my lord, does not apply here because my lord, the shares are under dispute. I can't say, my lord, NSDA rules, my lord, will override, my lord, orders of court.
Yes. In IA number 3216, that is the temporary injunction petition, you will be filing.
Well, I filed
Yeah.
already, you have to fix it for you. I have already filed on
Mm.
reply.
Okay.
Only 3982 and I couldn't file because she is not there, so we have sent it for waiting.
But it's
and
by
affidavit.
constituted permit.
Once they come to file. Hello, one.
So 3983, my lord, has heard, my lord, that's the 151, that my lord is reserving for. Order. I want, my lord, the restoration, my lord, of the.
Heard Mr. R. Banerjee, Learned Senior Counsel, assisted by Mr. What is your name?
My lord, Mr. D.N. Sharma. My lord,
D. Sharma.
D. Sharma.
D. Sharma, Learned Counsel for the petitioner. Also Mr. K. N. Chaudhary, Learned Senior Counsel, assisted by Mr. K. Jain, appearing for respondent number 1. Also heard Mr. D. Majumdar, Learned Senior Counsel, assisted by Mr. S. Hajurika, Learned Counsel for respondent number 2, as well as Mr. R. Chakraborty, Learned Counsel, appearing for respondent number 3. Learned Counsel, the written objection filed by the respondent number 2 against the instant application filed by the petitioner is received, is placed on record. I have heard Learned Counsel for all the parties on the prayer made in the instant interlocutory application for reversal of the transfer of 861918 numbers of share of company BNA Limited from the account of respondent number 2 to the earlier demat account of what was the earlier account number?
My lord,
ID
30.
ID is different.
DPID number, my lord. Quickly.
Lord, will find in the plain.
301151.
301151. That is the account which was held by late Hemendra Prasad Borua and respondent number 2,
Sharmila Shetty.
Sharmila Vijay Shetty, prior to the said transfer. Stop.
Not a transfer, it's transmission, I see. Earlier.
That is the prayer. I
That's the
am
prayer.
using the prayer
Prayer
language.
with my lord, always.
Let this matter be listed for delivery of orders on January 22nd. No, I may need more time.
Yes, my lord,
Yeah.
whatever my lord is.
28th
Any date can be. Any date.
28th January. 28th January.
Great.
In other matters may be listed along with the In other matters, the names of the council, list these matters on 28th January.
My lord, no hearing, my lord, I take it, my lord, we are not required, my lord, our presence
No,
is.
no.
Each one to be extended.
Or we may do one thing. We may dispose of 151 petition on 28th January
Yes.
and fix the other
Yes,
matters
yes,
for
yes.
hearing
Correct. Correct.
on a convenient date.
Absolutely.
Choose a- You choose the,
Lord, may decide on that day, man, no. On
no,
that-
that day your presence may not be required in that sense. If
Sir,
I,
any day in February.
151 will be disposed of
Yes.
and February first, second week of the 13th. 12th of February.
All right.
Other matters,
On
the FAO as well as the other IA on 12th of January.
The 28th of January.
12th of February. 12th of February.
Very good.
Interim order be extended. Interim order will continue. Interim order.
The interim order, my lord, can be, my lord, extended to 12th of February.
Yes, interim order shall continue.
We'll file our reply to that injunction violation. 398. 398. We have not filed till now.
Okay. Interim was in 3983.
My lord, interim order, my lord,
In the main appeal.
in my lord 3216.
321.
Interim order
In the main appeal.
3216 of the interim order shall continue.
And my lord, since my learned friend, my lord, will be using an affidavit, if my lord required, we'll also file a rejoinder affidavit, my lord, if required.
Yeah, that liberty is there.
My lord.
The copy which you have provided, I have marked it, therefore I will keep it with myself.
Noted.
I'll return it on next day.
That, my lord, now becomes court's property, my lord.
We will not
Not
take
common.
another copy from them.
Now we can't be, my lord, privy to, my lord, anything.
Absolutely no difficulty.
Then you will not get it back.
Yeah, that's part of court report.
My lord, grateful. my
We'll
lord.
constitute a separate copy for us.
Yes.
My name is shown in the cause list, only, it's not shown.
Name of Mr. R. Chakravarti should be reflected in the cause list as engaged counsel for respondent number 3 henceforth.
I'm extremely grateful. Sorry, my lord, we troubled my lord.
For very patient.
মুনমুন কিবা অসুবিধা পালে দিল। Yes. Yes.
Please, your lordship, lordship may kindly see order dated 15/12/25, lordship. For service of notice in respect of respondent number 2.
Yes. Track consignment report is there.
No, my lord. Lordship may kindly take up the matter, item number 17, my lord, because he is the common party in this case also. There is a office note in item number 17.
Item number 70.
There is a office note, my lord. In respect of respondent number 2 in this case, my lord, there is a office note in 5/1/2026.
Yes.
So he has left the place, my lord, actually.
So what is to be done?
We go for paper publication.
Paper publication in both the cases.
Both the cases.
My lord, in item number 16, extra copy maybe.
I'll furnish.
Okay, heard Mr. T. R. Konita, learned counsel for the appellant. Also heard Mr. B. R. Das, learned counsel appearing for respondent number 1. On perusal of office note dated 11 office note dated 5/1/2026, it appears that the notice is sent to respondent number 1 and 2 could not be dispatched due to shortage of postal stamps. However, learned counsel for the petitioner submits that the respondent number 2 in this case is also a respondent number 2 in MSC appeal number 460/2025. And in that case, the notice issued to respondent number 2 has returned with a report that the respondent number 2 has left the place where he is shown to have lived. Under such circumstances, learned counsel for the appellant has prayed for allowing the appellant to take steps for issuance of notice upon respondent number 2 by substituted mode of publication of the notice in newspaper. Considering the circumstances as well as of this case as well as submissions made by learned counsel, the prayer is allowed. The petitioner share 2 newspaper.
So he is from Goa, my lord. That is why we have to find out what newspapers are, widely circulated, my lord. So it might take some time, my lord.
Okay, 2 newspapers.
2 newspapers, my lord.
The appellant shall take steps for issuance of notice upon respondent number 2 by publishing the said notice in 2 newspapers which are circulated widely in the address, in the known address of the last known address of the respondent number 2. The date of appearance in the said notice shall be shown as 10th of March.
10th of March, my lord.
Okay,
My lord.
10th of March.
For IA, my lord, the stay may be continued, stay may continue.
My lord, I may be given
In item
time,
number 16, my lord.
because of he is not furnished any extra copy, so.
10th of March.
Uh,
The appellant is directed to furnish copy of memo of appeal along with annexures to the learned counsel for respondent number 1 within 2 days
2 days.
from the date of this order. The interim order is there.
Interim order is there, my lord, item number 16, 24/9/25. 3201, I remember.
Where is the interim? There is a separate I.
Separate I.
Parties likhebo. It appears that in the connected MSC appeal, the appellant has been directed to take steps for issuance of notice upon respondent number 2 by substituted mode of paper publication. Stop. Hence, in view of the above, let this case be listed also along with the connected MSC appeal on 10th of March. The interim order granted earlier shall continue till next day. In MSC appeal number 17, same order, some modifications will be required.
My lord, in item number 17, I have a file and IA for direction to deposit 50%. So I number.
Your stay is there.
No, stay is there.
You are paying for stay.
Yes, my lord.
Will you deposit 50%?
Lordship, given the facts, my lord, this is a case of pillion rider, my lord, and
No, my lord.
You file objection against I. Where is the I? Item number 16.
17.
Item number 17.
I number 3536 of the 25.
Before.
326424.
No, the deposit of 50% question will come only if stay is granted.
Stay is not there.
Stay is not yet granted.
Yes, sir.
So the question of deposit of 50% does not come now. Only while considering stay application. So
Okay.
this application will be considered along with the stay application.
My lord, they are not still file any stay, my lord.
We
In
have
the,
filed
in
a
the,
stay, my lord.
my
We have
lord,
filed stay
my
petition, my
lord,
lord.
their objection is that only on insurance policy.
No,
And that
just a minute. Heard Mr. T. Kolita, MSc appeal. Heard Mr. T. Kolita, learned counsel for the applicant. Also heard Mr. B. R. Das, learned counsel for respondent number 1. On perusal of the office note dated 5/1/2026, it appears that the notices issued to respondent number 2 would not be served on him, as the flat in which he was residing on rental basis he is no longer staying in the said flat. Stop. Learned counsel for the appellant prays for allowing the petition appellant to take steps for publication of the notice, steps for service of notice on respondent number 2 by substituted mode of publication of the notice in the newspaper. Where is the law? The appellant shall take steps for issuance of notice on respondent number 2 by publishing the notice in 2 newspapers which are widely circulated in the last known address of the respondent number 2. The date of appearance to be shown in the notice shall be the 10th of March. Let this matter be listed accordingly. Then IS. What do you want this IR to be disposed of today?
Yes. Subject to, stay may be granted subject to 50%.
My lord, lordship may kindly see the grounds, my lord. Because this is settled position of law, my lord, that the pillion rider is not covered, my lord, under NAC policy, my lord.
No, my lord, it's a pickup policy. They have filed affidavit with exhibit and DW cross-examined. In cross-examination, it is admitted by that the policy is package policy and two-wheeler, 2 seats and premium.
Package policy.
Yes.
Check policy, my lord, but because there
It
is
is
a,
admitted fact.
let me submit. But during cross-examination, my lord, the DW
What
one
the
has
trial court has held, what the tribunal has held,
that
package
he's covered,
policy.
package policy. In fact,
Then
it's
pay
a-
50%. If it is found to
Lordship-
be a
Lordship,
only
it's-
policy, they will return it
in
with
fact,
some.
Lordship, the dispute is not with them, my lord. Because the liability is to be shifted to the owner. That is why his presence is required, my lord. Because the policy is act policy, that doesn't change the nature of law, my lord. Because the act policy is very clear on that aspect, my lord, that pillion rider is not covered. And moreover, the second ground, my lord, the case was filed under section 163A, wherein the income has to be 40,000 per annum, my lord. Now the case has been decided, considering the income of the deceased at 8,000 rupees per month. It is another aspect is there, my lord.
Okay, we'll issue notice in both the IA. Three, 2, 6, 4. In I number 3264, heard Mr. T. Kolita, learned counsel for the applicant. Also heard Mr. B. R. Das, learned counsel for respondent number 1. The notice issued to respondent number 2 has returned with an endorsement that he has left the address in which the notice was sent. In the main appeal, in the connected MSc appeal, the appellant has been directed to take steps for issuance of notice through substituted mode of publication of the said notice in newspaper. The notice of present interlocutory application shall also be issued in the same said mode, along with the notice of the MSC appeal number 460/2025. The respondent number 1 has filed an interlocutory application which has been registered as IA number 3536, praying for directing the insurance company to deposit 50% of the awarded amount as a condition for stay, grant of stay. The said interlocutory application shall be treated as a written objection in the instant interlocutory application. Let this case be listed on 10th of March. You can go for execution for the trial. I am 10th of March. Yes, what is this?
Hello. The tenant of the respondent. I have filed one application for calling of the missing case logo. That was earlier allowed, but subsequently the on account of non-taking of steps, that was my prayer was kindly peruse the order dated 18/5/2023, page number 62.
In this revision petition, which order you are impugning?
Filling 3 orders.
3 orders.
Order dated 22/6/23, 6/7/23, and 11/8/23.
But you can make only one prayer.
Well, one prayer is.
Oh, okay.
On 18/5/2023, page 62.
Yes.
Both sides are duly represented by the relevant counsel. Peruse the case records. After perusal of it, since that the court by order dated 28/3/23 has directed the defendant side to take steps for calling of NJ reports, and as such the opportunity was given to them. It is seen that since 8/6/2023, the matter was fixed for calling of NJ records, and even on previous date, they have defaulted in taking steps. The defendants have verbally stated that due to certain unavoidable circumstances, they could not take steps on last date, and as such, I am of the opinion that for the ends of justice, a chance may be given for calling of the NJ case records with a cost of rupees 500, which is to be payable to the plaintiff. Also, inadvertently, the court by order dated sessions has fixed the matter today for cross-examination of PW, but upon perusal of the case record, it seems that the cross of the PW has already been conducted, and as such, the court deems fit for proceed the case towards next stage, fix it now for evidence of DW and calling of NJ records. And accordingly, on the left-hand side, the requisition for NJ case records issued by memo number such and such on 24/5/2023. I have taken the steps.
No, which portion you are aggrieved in this order?
In this order, I am not. This order I have not challenged. I have shown the
direction for taking steps.
yes, and accordingly I have complied.
When?
On on the same day I have submitted and it was issued on 24/5/2023.
Okay, thereafter,
Thereafter, on the 22/6/2023, the records are not received and a court has directed me to take fresh steps. That is page number 63 and that is typed copy and the order is.
this you are not
64.
impugning.
This I have impugned
Which portion?
because on that day, when the records were not transferred to the court may direct the solicitor or the dealing assistant to show cause as to why you have not furnished the copies. They have not given any reply why they have not sent
Yes.
in spite of receipt of the notice for requisition. On that day, the order in the e-court was not fully reflected. So I have annexed the order on the e-court order at page 65. On that day, the business was DW's/NJ case record on 22/6/23 and the next date defense witness 6/7/2023. I have the impression that the records have received because on that day, the order was passed in the late hour. The court restricted let the records if they receive, then I will pass the order.
No, court only issue reminder.
Issue reminder, but in the e-court order, it was not reflected. That's why I have not taken the steps on that day.
Okay.
Thereafter, the order dated 6/7/23. Type
Okay.
copy is page 66. Parties on both sides are represented. Peruse the seer. Learned counsel for the defendant filed a petition number session praying for filing another date for
You
filing
have to
evidence
stop.
for-
I have some urgency. We'll continue tomorrow this case. This case at what time?
10:30.
No, my lord,
Not-
because I have to another matter at 1:08
Choose your time.
at second afternoon.
At two. At two. Heard Mr. Karthik Moore, learned counsel for the applicant / petitioner. Also heard Mr. N. Alam, learned counsel appearing for the respondents. Due to paucity of time, the matter could not be heard completely. Let this matter be listed tomorrow at 2 p.m. as part of matter.
Can I pass the direction for going my name? This is already there in order.
The registry is directed to reflect the name of Mr. N. Alam as
Counsel for the respondent.
counsel for the respondent, along with Mr. S. Bhatia. S.A. Bhatia.
Your Lordship, item number 9 and part heard matter.
Pacha.
Your Lordship takes it on execution case has been started, People leadership take it till tomorrow or 19th.
Tomorrow is not possible. 19th. 19th due to paucity of time. Item number 9 and 10. 19.
Written argument, can reply on the written argument.
Then it was to the Lordship.
It would be better if you file a written argument on 19.
Lordship, item number 23, Lordship. Your Lordship directed us to submit written argument. We have prepared it, Lordship. we have submitted. Item 23, Lordship.
Item number 23. Who is on the other side? You file it today. We'll fix it again on 2022 for filing return.
That is item number 22, it was only for withdrawal of the FDR. My learned friend is representing the insurance company. They also don't have any objection, Lordship. So it may be allowed. Lordship. Item 22,
You don't have any objection. Item number,
22, Lordship. I 4120.
I will allow, but you have to go through order tomorrow only.
Lordship, with respect to item number 25, it's a part heard matter. Can it be fixed in any date, my lord?
Item number
25,
25, fixed date due,
in the top of the list, my lord.
12th of February.
I'm obliged. What's okay? Lordship, item number 19, any date may be fixed. It's same matter.
12th February.
My lord, item number 33 is supplementary. It may be fixed on 19, my lord. Supplementary item number 33 and 20,
33 and 2019.
19. 33 supplementary. Yes, my lord.